Good morning. This is the Colorado Energy and Carbon Management Commission. It is November 29th. It is 9 a.m. and we have our business agenda ahead of us. To begin, we will do a roll call of commissioners.
Thank you. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Oath? Commissioner Ray? Commissioner Robbins?
Here.
Mr. Chair, you have 5 to 7 commissioners present.
Excellent. Good morning, everybody. Good to see you. As always, we are undertaking our business of the state via Zoom. We've got 54 people participating with us and counting, and we've got a busy agenda. So let's just jump right in. We will start with commissioner comments. This is the opportunity for commissioners to bring ourselves up to speed with each other in the work that we're doing. Any commissioner comments for this morning? Commissioner McGowan.
Thank you, Mr. Chair. And maybe not necessarily a comment, but a request. I was in the permitting section of our website while reviewing another OGDP, and I noticed that WaveTech has 8 more pending permits in front of us, which I don't have an issue with. But I think in a past hearing, I had requested WaveTech maybe consider some sort of a comprehensive plan with the commission so we would understand how development was going to happen. Everything is in Cheyenne County so far. And I guess I was wondering if the commission would be open to putting on the agenda somewhere in the future a discussion between us to request WaveTech pursuant to Rule 314.3A3, which is the ability of the commission to direct the director to meet with an operator to discuss whether the submission of a cap is appropriate, pursuant to 303A8, which is when an operator is proposing multiple oil and gas locations in a similar geographic area. Just to open up the conversation. I'm not necessarily sure that it has to be a cap, but I would appreciate maybe a bigger picture, a landscape view of what's happening with helium development.
Sounds reasonable to me. I had not looked ahead as you have, so I appreciate the look-see out. I think we can just, if everybody else is in agreement, allow this to be direction to the director to sort of schedule that sort of a meeting with WaveTech. Do you want to have that meeting yourself, Commissioner McGowan, with staff and WaveTech? If it's a meeting with all 5 of us, then it's a public meeting, and it may be easier to have a discussion purposes if you and staff are having that meeting and you could report back. I don't know if you'd thought about that.
I hadn't thought about it. I was thinking maybe of just putting something on our agenda so that's, I haven't talked to WaveTech about this other than the comment I made during a previous OGDP hearing where I was interested in seeing them perhaps address this. And they expressed a willingness, but I haven't seen anything happen. I'm just wondering if the commission maybe wants to have a conversation about whether or not so for me, I'm not sure it needs to be a full-blown cap, but maybe there are some things the commission would like to see as part of a landscape picture so we can make sure that those items could get addressed in a conversation with the director, with the staff. Or if you just, I feel like I don't want this to be the deciding point right here because I'm doing it during commissioner comments and that doesn't feel very transparent.
Commissioner Messner.
Thank you, Mr. Chair. Commissioner McGowan, I appreciate you bringing this up. I think it makes sense. I think the rule as I read it indicates that we can make a request that the director meet with the operator as far as looking at different opportunities for comprehensive area plans or something like that. And so it may be best if we just follow the rule and make a request to the director to have those conversations and then report back to us, at which point we could have a discussion.
Yeah, I think that makes sense, Commissioner Messner. So with that, are the other commissioners in consensus with Commissioner McGowan's request to the director? Commissioner Ackerman?
Thanks, Mr. Chair. I am. I just wanted to also put a plug in for, the the area in which they're operating contains a threatened species, the lesser prairie chicken, and I would ask that that be, if it's amenable to Commissioner McGowan, a bit of a focus of the director's discussion with the operator.
Good additional clarification. I don't know that we need to have a motion. I think the direction is articulated here. I will encourage Director Murphy, who is absent at the moment, to go back and listen to this recording and then set that matter up for a discussion between the director and the operator, and then to report back. Is that fair?
Mhm. Thank you.
All right. Any further commissioner comments? Commissioner Messner?
Thank you, Mr. Chair. Just a couple of quick comments. I wanted to let the commission know I had an opportunity to present in front of the Western District at CCI yesterday. And it was a good conversation with the different counties on the Western Slope about some of the new authorities that have been provided to us and some of the upcoming work that we'll be undertaking. And so I had an opportunity to do that. And then also just want to inform folks that the next Colorado Produced Water Consortium meeting will be held on Friday. And information and links to participate in that are on the DNR website. So,
Excellent. Thanks for the update. Thanks for the good work there. Other commissioner comments? Commissioner McGowan?
Sorry. I just also wanted to add that Commissioner Cross and I are going to host some community meetings around our upcoming cumulative impacts rulemaking, December 6th, 7th, 8th, and 11th. I think we have, Commerce City, Rifle, try to remember our other locations. They're posted on the website. They're in the evening. We are offering snacks and childcare for folks who want to come and talk to us about cumulative impacts and potential impacts on disproportionately impacted communities, and input from those folks about what they'd like to see in our rules. So looking forward to those meetings and hosting them.
Great commissioner comment, and really appreciate your leadership there, Commissioner McGowan, and thanks for the second chair there, Commissioner Cross, and being available for those meetings. Did you have something you wanted to add, Commissioner Cross?
Was just going to say the other two are in Greeley and Erie.
Okay. Lots going on. Other commissioner comments? All right, moving forward, we next have consent agenda on our schedule. Are there commissioners with questions with regard to consent? And if not, do we have a motion to approve consent?
move approval of the consent agenda.
Second.
Motion and a second to approve the consent agenda. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. All right, next up is docket 2309-00287. This has to do with a number of Form 2s that we have elevated for consideration at the commission. This involves the operator extraction. The 2s are denoted the Coyote Trail 2s. And before us today is not the substance of the matter, but instead are some procedural motions, particularly two motions to dismiss filed by extraction to dismiss the petitions of a couple of local governments that are located within the vicinity. Because these are legal matters and involve the legal issue of standing, I would like to elevate AAG Davenport to allow him to provide us with some legal perspective on the pending motions to dismiss. Attorney General Davenport.
Thanks, Chair. I know the commissioners have seen the motions to dismiss and the responses as well as the petitions. So
Hey, one thing, Kyle, I'm not inclined to elevate the lawyers for additional oral argument on the motions. And I'm doing that not because I don't like to have lawyers argue in front of us, but instead I think that the pleadings, the written pleadings, have adequately provided the arguments. And I'm informing the lawyers that the commissioners have all read the pleadings quite extensively. And so we've got the lawyer arguments in front of us, and we do not feel the need for additional oral argument. So sorry to butt in there, but I wanted to make that procedural note.
Sure, thanks, Chair. I think the commission may still ask questions, of course, if you have them of the movement and respondent local governments. Commissioners, so my plan is not to go through what the petition or motions or responses say. I do have some thoughts on the legal issues presented, and as the chair requested, I'll give those to you now. Rule 507, the ECMC rule on standing to petition does apply in this case. During mission change, the commission included in Rule 507 that relevant local governments defined as the local government with land use authority where existing or proposed oil and gas operations occur with automatic standing. The old pre-mission change rules did not provide for any hearings on permit applications, so that was not a process that was under the previous mission change or volunteer commission. In this case, Broomfield and Erie are not relevant local governments under that definition and therefore must demonstrate standing pursuant to Rule 507. Rule 507 tracks the APA's requirement for standing, and the statement of basis and purpose for the 200 through 600 series mission change provides that the commission's intent was to use relevant case law addressing the scope of standing to be as persuasive authority for the commission to reference when addressing questions of standing. That's page 106 of that SBP. Like here, I believe there is relevant case law from most specifically very recent case law from the Colorado Supreme Court's opinions in two cases, Weld County v. Ryan and the case that I'm going to address in more specificity now, Colorado State Board of Education v. Adams County School District 14, where the Colorado Supreme Court addressed a claim by the school district that the state board's use of what were called cut scores to measure performance injured both the school district itself and violated equal protection rights of economically disadvantaged non-white, non-English speaking students in the school district. The school district attempted to bring claims on behalf of its students in that case. The Supreme Court held that the injury alleged by the school district to itself was too far removed from the school board's use of cut scores to be an injury in fact. And because the school district failed to allege an injury in fact to the school district itself, it did not have standing to bring claims on behalf of its students. Applying the Supreme Court's holding in that matter, I read that opinion to mean that in this case, the local governments must allege an injury to themselves as governmental entities before they may bring claims on behalf of their residents. Alleging only an injury to residents under this opinion is not sufficient alone to confer standing on a local government. In my view, the companion case to this, Weld County v. Ryan, provides additional detail on how local governments must allege direct injuries to themselves to have standing. So I think that is relevant case law that to standing that the commission under its statement of basis and purpose and mission change did intend to consider when questions of standing are raised. I would note two things before I conclude my comments. First, that under Rule 507, the residents themselves may have standing to appear on their own behalf to petition to be a party. And I would also note that party status, which is what is at issue today, confers some rights, such as the ability to cross-examine opposing party witnesses, but a person does not have to be a party to express their views to the commission through public comment. That concludes my thoughts. Mr.
Thank you,
Chair.
AG Davenport. Let me ask a question on that last point, the point regarding party status versus an ability to participate with us. If we were to come to the conclusion that under the relevant case law and under our statute and under our rule, neither local government has standing as party status, do I have the ability to ensure that the communities have an ability to sort of present their case, without having the ability to cross-examine and otherwise act like a lawyer? Could they still be able to present their perspective on the proposed APDs?
Yes, the ECMC has a very broad public comment rule that allows anyone to provide public comment. So the commission could certainly provide public comment opportunities and effectively already has provided public comment opportunities to local governments and expand that opportunity in terms of time as well.
Okay. Well, commissioners, this commissioner appreciates the legal advice that we've received on this matter. I would note that from my recollection, we did a very good job during 181 rulemaking of elevating opportunities for local governments and other citizens within the state to participate before us. The participation ability that exists now is far greater than existed previously. And we've seen that in the work that we do weekly on Wednesdays with folks that participate with us. I also would note, from at least my perspective, that we tried to put together a thoughtful participatory process in that we elevated actual standing at all times to the relevant local government. And for folks that are listening in, the relevant local government is the local government with land use jurisdiction over the particular action. In this case, and we also did not elevate always standing to proximate local governments. And for folks listening in, proximate local governments are local governments that don't have land use jurisdiction, but that are nearby to the proposed location. In this case, both the proposed communities are proximate local governments. They have provided some significant information to us. They all ask for standing as a party. The operator moved to dismiss them as party. I think under the appropriate case law and under our rules, they ought not be granted party status, but I'm very interested in ensuring that they are granted the opportunities necessary for them to sort of state their case. That could include more time to present their case than the normal 3 minutes that we provide folks. That could include their ability to file written documents with us, et cetera. The preclusion of party status would not allow them for cross-examination and openings and closings and stuff such as that. But I don't believe that forecloses a very adequate opportunity for these communities to bring the important information they want to bring to us. I think that, so those are my musings on this topic. Happy to hear from other commissioners. Again, we're merely taking up the procedural matter of the motions today, and that's to sort of set the framework for how we will actually hear the case in another bit of time. I would note that we suggested to the director that we wanted to see a CDPHE consult on this matter. I've touched base with our CDPHE liaison, and that consult has taken place, and the written report is being put together at this point. I think we should generate a little time before we take the substance up on this, assuming we decide the procedural matters today, to give the parties and CDPHE an opportunity to finalize that consult so that's adequately brought before us. So I would suggest that if we take up the motions and make a decision there, that we also suggest to the hearing officer that he have a hearing pre-hearing conference with the parties here, whether they're standing parties or they're participatory parties, to define out an appropriate schedule so that we can not only hear from the applicant, but hear from the communities, whether they have standing or not. So those are my thoughts. I'm happy to hear from others before we make a decision here. Commissioner Messner.
Thank you, Mr. Chair. I wonder if AG Davenport could visualize himself again, and I just want to clarify a couple of things so that I better understand it. And you know, as I reviewed this, you know, I also, you know, looked at the statement of basis and purpose and the rules and the relevant case law, and would concur that you know, in Rule 507, that, and this is in the statement of purpose, that the commission based the standing provision of Rule 507A on the Administrative Procedures Act's provision governing standing and adjudicatory proceedings. And it also indicates that the commission intends for case law addressing the scope of standing provided to be considered as persuasive authority for the commission to reference when addressing questions of standing. And so I agree with you there. That's also what I read. And I think that the case law that you've provided is, you know, does provide some clarity on that question. But I do want to just emphasize that there is standing for affected persons, for any affected persons inside to the 2,000 feet of a proposed working pad surface. So so while the relevant local government has automatic standing, the residents and other surface owners and even building owners and tenants have automatic standing within 2,000 feet of a proposed working pad surface, you know, in situations like this for future consideration, if people are wondering whether or not they have automatic standing or not. Am I correct on that?
Thanks, Commissioner. Yes, you're correct. So I believe you're referencing current Rule 507A2, which provides that for purposes of applications filed pursuant to Rule 503G1, surface owners and residents, including owners and tenants of building units located within 2,000 feet of a proposed working pad surface are affected persons, meaning that those folks have already been predetermined by rule by this commission in adopting that rule to be affected persons and therefore have standing to petition and be parties to OGDPs in that case.
In this particular situation, because we've got a couple of proximate local governments requesting standing or party status, that's where that initial application of the case law lies. It's not within the affected residents or the building owners or the relevant local government. It's because the actual proximate local governments have applied for standing, and in order for them to gain standing as per the relevant case law, they would have to show injury in fact to the proximate local government itself, not necessarily just the residents within that proximate local government. Is that, I'm trying to take it into my words so that I better understand it, because I'm not a lawyer. So
sure, that's correct. So Rule 507 generally, in regards to standing, does two things. It gives automatic standing to certain governmental entities, and as we've already discussed, people residing, et cetera, within 2,000 feet. But it still provides that anyone else who can demonstrate that they have standing may participate as a party. And that's where proximate local governments fit in. They do not have automatic standing, but if they adequately allege an injury that qualifies, they may participate as a party as well.
okay. All right, well, that's helpful. And I would agree, Chair Robbins, that you know, expanded opportunities for participation by the proximate local governments via public comment if this commission ultimately determines that those proximate local governments don't have standing, I think is important for us to do, to allow that that robust input that I think is certainly our goal in our hearing processes is able to occur, because while I agree in direct application of the law that the proximate local governments don't have standing in this particular situation with the arguments that they've made, I do think local governments do have a responsibility to speak on behalf of their residents, and I think that there's an opportunity to do that through the public comment, expanded public comment opportunities. So.
Thank you, Commissioner Messner, for the clarification. I think that's helpful. And, you know, I would note that this theme of hearing from the relevant local government is very, very consistent with the work that we always do. I would note, for example, that we hear from Weld County on any application that it is the relevant local government upfront and early and often. And so I think that similarly, hearing from proximate local governments that have concerns is consistent with the work that we're doing. And I'd note that Hearing Officer Berman is in the panel and listening in, and so I think he will be able to take this direction and codify a pre-hearing order that ensures all of the requisite participation by the proximate local governments, assuming we get to the point where we agree that they're important, but disagree that they get to that elevated status of party status, and instead they can come before us. Do any other commissioners have thoughts on this? Commissioner McGowan?
Thank you, Mr. Chair. I just want to point it out too that this is an interesting little wrinkle because we're not talking about an oil and gas development plan. We're talking about the review of a Form 2, which the commission really hasn't taken upon itself. That usually goes to the director. It's usually kind of administrative. And so that it does feel a little contrary in our attempts, I think, in our rules to give proximate local governments a voice in our decision-making process. But this is different than an oil and gas development plan. This is a Form 2. And I understand what AG Davenport has presented to us and the case law behind when a local government has standing or not. So I also am very supportive of ensuring that we're providing ample opportunity for the proximate local governments to be, I guess, what you called shared, participatory parties, and making sure that they have an opportunity to state their thoughts as part of the public input process.
Commissioner Cross, Commissioner Ackerman, anything else for the good of the cause? Commissioner Cross?
Thank you, Mr. Chair. And I'll just make one final point is I agree with the standing analysis, and I think it is important for all those listening in and for those that may listen in at a later time. I do think it's important for individuals also to take the opportunity, especially when they're within 2,000 feet or nearby oil and gas proposed operations, to take the opportunity to comment if you feel strongly about it as well. Because I think that the fact that we didn't hear any is also noteworthy, and I do encourage people to take the opportunity to comment and participate in our hearings.
Okay, with that, I would make a motion that we deny standing or that we grant the motion to dismiss relevant to the standing arguments of the petitioners. AG Davenport, did I get that right? Close enough?
Yes, Chair, I think the appropriate motion, as you've already stated, is to grant Extraction's motion to dismiss. And
so I would move to grant Extraction's motions to dismiss. The motion would also include direction to the hearing officer to create a pre-hearing conference that establishes the appropriate amount of ability for the two communities to participate with us so that we can hear their voices and their matters as not party status, but as a proximate local governments.
Second.
Motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? All right, motion carries. Okay, commissioners, with this, we have finished up that docket. We're now going to turn to docket 2207-00198, an oil and gas development plan. MRG is the applicant. We have a number of folks that are also going to provide public comment. I'd like to take a 5-minute break. I'd like hearings manager Angelica to set up our timer. Let's return at 9:35, and we will start on that docket with hearing from the public. Thank you. All right, welcome back. This is the Colorado Energy and Carbon Management Commission. It is November 29th, 2023. It is 9:35, and we will get our work on 2207-00198 MRG oil and gas development plan. I see Ms. Ryan, the attorney for the applicant, is on our panel. Ms. Ryan, just checking in. I was planning on going directly to the, I think, 11 public commenters. followed by a presentation from Larimer County, if that's still there, and then we would hear from you. Is that sound adequate and fair in terms of process? You're muted, but I see you're shaking your head. So,
Great, thank you.
okay, thank you very much. All right, with that, we're going to move to public comment. We appreciate the fact that folks have taken time out of their day to provide us with information about this docket. We will start with Tammy Friel, who is elevated. If she would like to unmute.
Hello. I'm here to talk about the oil and gas proposal submitted by MRGLP that's being considered today. I am in full support of this proposal and believe it should be approved. The project isn't just about extraction. It's a significant boost to our economy. We are looking at increased tax revenue, new job opportunities. It's a win-win for our community. What I appreciate about this company is their transparency. They've taken time to educate the community, offering tours of similar operations nearby. That kind of openness and accessibility demonstrates they value community and the quality of life for its citizens. And here's the kicker. They're not just meeting the already strict state and city requirements. They're going above and beyond. The standards are tough, but they are aiming higher to ensure safety and responsibility. So let's consider the bigger picture here. This project isn't just about drilling. It's about boosting our economy, creating jobs, and doing it while surpassing what many believe are the strictest rules in Colorado and the nation. I'm in favor of giving this a thumbs up. Let's support growth while ensuring we're doing it responsibly. Thank you.
Mr. Chair, you're muted.
Sorry. Thank you, Ms. Friel. We appreciate your taking time to come before us. We will now hear from Scott Holst. I see we have a Scott on our panel. Hopefully that's the right Scott.
Yes, it is. Can you hear me okay?
We can. Mm-hmm.
Okay, great. Thank you, everybody, for the time today. I'm speaking on behalf today of our family, which is a fourth generation Colorado family, in particular in the Loveland area. Members of our family over the years range from a retired fire chief of 20 plus years, numerous entrepreneur, business owners, accountants, and most importantly, farmers and cattle ranchers, to include the old Simpson Farms, which was part of my family, better known now as Simpson Ponds Wildlife Area. I think it's extremely important today for us to understand fossil fuels are a critical and practical bridge toward a future potential non-fossil alternative energy sources, and those becoming competitive and reliable. But they're simply not there yet. They're not cost effective, not efficient. Responsible energy development in this area, such as this MRG project, is absolutely a necessity to support our Colorado economy. The families that work in this area, the taxes which support so much in our communities, including our schools, and maintaining affordable energy prices in the state and in the nation. I don't think we should try to fool ourselves. Fossil fuels will always complement future energy sources as they eventually develop. And I think Colorado's a choice here. Keep up with the responsible energy development path, which is proven safe and effective, in particular under our extremely strict regulations of our cities and state. We simply fall behind, not contributing to the local economy, not supporting our local families, the people who work in this industry and the people outside the industry, and not supporting our future advanced energy technology, most of which develops in these processes. So I ask that we move forward here with this MRG project and not take Colorado backwards. So again, I appreciate everybody's time. Thank you very much.
Thank you very much, Mr. Holst. We appreciate your participating with us. We now will hear from Jason Sherrill.
Good morning. Can you hear me?
Yes.
Great. Good morning, commissioners, and thank you for this opportunity to speak. As a local Northern Colorado homebuilder, a local resident and Colorado native, I am an advocate for sensible production of oil and gas. In my industry alone, our home buyers face multiple hurdles regarding affordability. The local production of oil and gas is a unique opportunity for our state and local leaders to lessen one of those economic impacts. that limit our residents' ability to afford to even live in Colorado. I strongly support this application as it represents best practices in the process of mining and producing oil and gas. Local production of oil and gas is a critical aspect of a strong economy and vital in our ability to ensure we provide affordable resources for our residents. Providing local affordable energy, generating much needed tax revenue, all within the strict City of Loveland regulations, which as mentioned, are above and beyond the current state regulations, is a perfect example of balancing industry and economical needs while protecting the environment and residents. So again, I strongly urge you to support this drilling application. Thank you.
Thank you very much, Mr. Sherrill. Appreciate you taking time and to provide us your perspective. We now will hear from Caleb Lisveld.
Thank you. Good morning, everybody. And my name is Caleb Liesfeld. I own a home very close to the proposed well location here in Loveland, and I am in full support of this proposal going forward. The need for domestic oil and gas is getting larger and larger. It drives our economy on a local level all the way to a national level. We've all felt the effects of inflation as of late. And as conflicts around the globe are getting more and more intense, our ability, even as a country, to maintain our supply chains and drive down surging costs for everybody, including all of our local residents, is getting greatly reduced. I believe it's our responsibility as a society to do what we can whenever the opportunities arise, and this is a productive way to do so. I'm well acquainted with the oil and gas industry and all of the regulations that go with it, and I also agree that the guidelines set forth by the state of Colorado, the city of Loveland, and also Larimer County are extremely strict, and they're guidelines that need to be met all the time. And thus far, I believe that MRG has done a wonderful job of keeping up with those and supplying all the information for everybody involved, and also keeping up with doing things safely for all parties involved. I have no doubt that they'll continue to do so. I've seen nothing to believe anything other than that. As stated before, I think that responsible energy development is absolutely necessary, and I believe that this is an effective way to go about it. I am in 100% support of MRG's proposal going forward, and I would urge all of you to be as well. Thank you.
Thank you very much for the coming before us and providing your perspective. We appreciate it. We now will hear from Doug Johnson.
Good morning, Commissioners. Appreciate the opportunity to speak in support of MRG's application this morning. Just a little bit of background. I'm a Larimer County resident and have been active in the clean tech community in Colorado for almost 20 years, and particularly working with startups in our community through our research labs at Colorado State University, CU, National Renewable Energy Lab. And I believe we're all working together for a fossil fuel-free future. Say that 3 times fast. And yet the issue is we're not there yet. And so we need reliable sources of energy, and MRG is going to provide that for us right here in our state, in our community, and I'm in full support of it. Here we have operators who have character. They're going above and beyond our state and local regulations. They've been transparent. They've engaged the community, and we're ready to move forward. And this is a company and a family that has a lot of character and will do what they say they're going to do. And they would be a good partner for the state and our local communities to provide energy. And so I would recommend full support for MRG's application. Thank you.
Thank you, Mr. Johnson. Appreciate you being with us and providing your perspective. We now will hear from Sherry King.
Good morning. Can you hear me?
We can.
Awesome. Thank you so much for this opportunity to share my thoughts and feelings this morning. I am a retired nurse, and I live within the city limits of Loveland. I want you to know that I fully support MRG's plan for responsible oil and gas development. I encourage you to do that as well. MRG has been very transparent during their permitting process, and they have conducted many neighborhood meetings and opportunities to take a tour of other sites so that we could see the perspective from their point of view of what's going to take place. I think MRG should be used as a model on how to develop community outreach the correct way. We need more responsible energy development in Colorado and a need to support operators like MRG. Again, thank you so much for allowing me the opportunity to share my beliefs, thoughts, and opinions this morning.
Thank you very much. We appreciate you being with us. We now will hear from, do we have Mark Goldstein?
Hi, yes, I'm on. Good morning.
Good morning.
Thank you for the opportunity to speak today. This is Mark Goldstein. I fully support MRG's proposal and implore the panel to approve their applications. MRG is a strong group with local ties and a team that has a history in Colorado. This team and the families made a positive impact to the local communities in the state for many years. These operators are local and have a vested interest versus other out-of-state operators working in Colorado who do not have the local ties and the community impacts that they have. MRG has done a very effective job the last few years working with the neighbors, the city, Larimer County, and other interested parties to explain their plans and projects and how they're going to mitigate impacts to the neighbors. They've gone, in my experience, above and beyond compared to other operators. We've have agricultural land in and around northern Colorado and have had firsthand experience with the out-of-state operators who come and who have and develop in the area. And I can say with certainty that MRG has taken community outreach and their efforts to show that they care and have a plan that will be very positive to the area to a new level. Responsible energy development is very important in the United States, and here in Colorado, we need more energy development to keep our prices affordable. Concurrent with some of the other folks who spoke today, the city of Loveland does have very strict oil and gas regulations that go above and beyond the state of Colorado requirements. And further, Colorado standards are much higher than other states, for example, Texas and Oklahoma. The energy industry is obviously an important part of the Colorado economy, and they employ many people in a very large part of our economy. One pad provides very high-paying jobs to our local community and keeps a number of very technical folks employed and engaged in our area. The taxes generated from the energy industry are critical to providing the funding we need for our schools and other services. I'm a dad of young kids and have seen the challenges that our teachers face in the Colorado education system. The teachers' impact on our next generation is critical, and it's really sad that they don't get paid enough to even comfortably live in the area. Responsible oil and gas development will continue to help boost their ability to make impacts on our next generation and live in the area. Domestic energy production is critical for Colorado, and we need to take it seriously. The MRG team has a good plan. They've thought through it very thoroughly, and I firmly believe they'll do a very good job in executing on their plan. We support the project and really hope that the panel will move it forward. Thank you.
Thank you very much. We appreciate you being with us and providing your perspective. We now will hear from Jeff Donaldson.
Hi, can you hear me?
We can.
Oh, good. Thank you for your time this morning. Yeah, I would just like to, I'm a neighbor. I live down the road about 2 miles to the north, and I would just like to voice my support for this project. I know the guys from MRG, the guys, they go above and beyond with everything they do it right. So I'm super confident that they'll do this project, and they'll do it just like they do everything else, and they'll do it with precision, and it'll be perfect. The other thing that gives me a lot of confidence is what the others have said is the city of Loveland's guidelines and rules are so strict that once those are met, I'm sure that I feel really confident that there'll be no negative impacts to our environment. And then just like we're seeing this everyone's trying to find an alternative energy source, and right now, electric has not really proven itself. So I think it's imperative, and I think we have to be responsible and be good stewards and go get these fossil fuels that we're so blessed to have in our country, so that we can pass those savings on to our citizens and our and try to nip away at this inflation costs, and just for the benefit of Americans. So I am 100% in favor of this project. Thank you for your time.
Thank you, Mr. Donaldson. The next person that signed up is Jessie Donaldson. Would that be someone you're familiar with? And is she going to present?
Yes.
Hi, can you hear me?
We can.
Okay, wonderful. I support approval of MRG's application because McQuinney Group, they've been developing in our area for years and years, and they are some of the most professional and responsible local developers that I know. They're local, they have a track record of doing quality projects that always add benefit to the community and the local economy. And I don't see why it would be any different with an oil and gas operation that they're in charge of. I believe they have a vested interest in Colorado and Loveland because they live here, and they understand how vital oil and gas production is to our state's economy and energy security. And for those reasons, I would hope that you would approve their application.
Great. Thank you very much, Ms. Donaldson. We appreciate you being with us. The next person that has signed up to present public comment is Amber Duran. I understand Ms. Duran has declined the ability to come on our panel. If she wants to present, accept the panel invitation. If not, that's fine, but do want to give you the opportunity to present if you so desire. The last person is Jennifer Martinez, and I see that we have a Jen Martinez on our panel, so you are recognized.
Yes, thank you. Good morning, commissioners. Thank you for allowing me the time to speak. As a Larimer County resident and a mom raising a family, I support this application to produce oil and gas. MRG and McQuinney team has a responsible, well thought out plan. They have a reputation of doing great work in the state of Colorado, and they do a good job of public outreach. MRG Group also has standard operating procedures to ensure environmental safety. As we're on the road to use renewable energy, our society isn't fully to that point yet. And because of that, projects like this are still necessary to heat our homes and fuel our communities. Also, the taxes and royalties from oil and gas production can provide a substantial source of revenue for the local and state governments. Our teachers don't get paid enough for the work they do, and the economic benefit this could provide to our schools would be greatly beneficial. The revenue can also be allocated to fund public services and infrastructure development, benefiting our entire community. As well, oil and gas production, typically requires a diverse workforce, ranging from engineers and geologists to technicians and support staff. Supporting the industry can result in job creation and providing livelihoods for local residents. And this economic activity can have positive effects on the standard of living and the overall prosperity of the community. And for this, that's why I support this application.
Great. Thank you very much.
Thank you.
All right. I see Ms. Duran has now appeared. Would you like to provide us public comment? Ms. Duran, first you'll need to unmute. We cannot hear you. Ms. Amaro, can you help Ms. Duran present? Ms. Duran, you're now unmuted. Do you want to testify? We're still not able to hear you, Ms. Duran. I'm not sure if you're attempting to testify or not. All right, let's move forward. If we're able to identify a vocal Ms. Duran, we will hear from her later. At this point, we are going to move to a presentation from Larimer County. My understanding is that while they have withdrawn their petition, that withdrawal was premised upon an ability to provide us with some public comment today. If I'm wrong on that matter, someone please correct me. And I'm not sure who we need to elevate from Larimer County.
Thank you, Mr. Chair. We're in the process of elevating the speakers for Larimer County.
Thank you, Mr. Thomas.
Hello, Commissioners. This is Matt Lafferty with Larimer County. I think Leah Snyder's coming on as well as Frank Haug. is here from our attorney's office. So if I could, I'm just going to spend a few moments here. I'm going to share a screen. We have a brief presentation that is going to be conducted by Leah Snyder and myself. We appreciate this opportunity to make public comment to you all, and we have removed our petition as an impacted community, and we just wanted to voice our concerns regarding one particular matter. So with that, I would like to thank the commission for this opportunity to speak. We would like to thank MRG and the city of Loveland for including us in the process of evaluation of this application. We believe that we've had the majority, if not all but one of our concerns addressed throughout the process. And we would like to just share our thoughts with regards to the position of the county as it relates to some air quality matters. So with that, I'm going to turn this on and we are going to move forward with our presentation. Can you see my screen?
Yes, we can.
All right. So our primary concern here at Larimer County is the fact that air quality degradation is occurring in Larimer County and along the entire Front Range. We understand that the contributing factors to that are not just attributed to oil and gas exploration, but to many other facets that are out there. However, we do acknowledge that there are impacts that do derive our air quality issues as a result of oil and gas operations. As a result of that, Larimer County has taken a position that we believe that the Energy and Carbon Management Commission should consider conditioning the MRG LP site to limit the use of fossil fuel engines as part of the completion phase of the process during the peak months of the ozone season. And that would be, from our perspective, June 1st through August 31st. If they choose to use the equipment, fossil fuel equipment, we would just ask that it be operated outside of those periods. Otherwise, they've taken all efforts to electrify their pad, and we appreciate all those efforts that they've done up to this point. Just to make a point here today, in looking at the data from the American Lung Association for 2022, Larimer County contains Fort Collins, City of Loveland, those areas. We were ranked 18th worst air quality in the nation for various non-attainment area. And that is in combination with the 7th worst air quality, which is the Denver Aurora area and along the Front Range. And so air quality is of utmost importance to Larimer County, and we want to see that we protect that as best we can. So with that, I'm going to turn this over just briefly to Leah Snyder. She's with our Department of Health and Environment, and I'm going to allow her to speak regarding ozone. And when we'll come back after that, I'll come back and I'll just make some closing comments, and we will open up for comments or questions after that. So Leah.
Thanks, Matt. As Matt said, I'm Leah Schneider. I'm with the Larimer County Health Department. We have to go through a lot of these slides kind of quick, but just wanted to give you a little crash course in ozone. It is one of our primary concerns related to emissions produced by MRG. As many of you probably know, you've seen this image, ozone's a secondary pollutant. It's not actually directly produced from sources. It is actually formed when emissions from sources like cars, trucks, oil and gas industry, power plants emit emissions consisting of nitrogen oxides and volatile organic compounds. And then when these compounds interact under sunlight like UV and high temperatures, we start to see some ozone formation. Next slide. Okay, this is just a demonstration of our ozone season in Colorado. This is mean values, so you're not going to see our high peaks, but we're just showing you that May through September is the normal high ozone season here in Colorado. It's due to the high angle of the sun and warmer temperatures that we experience, which provide ideal conditions to create ozone. And our peak season is from June, July, and during the months of June, July, and August, as Matt said. Next slide. Larimer County is part of the 9 counties of the Denver Metro North Front Range severe area for ground level ozone. We're in severe non-attainment with EPA for our ozone. Larimer County also has 2 of the ozone monitors that are part of the Air Pollution Control Division's regulatory network for monitoring ozone, just so that we can evaluate our compliance with Environmental Protection Agency's National Ambient Air Quality Standards. And our monitor, and just note, these are great values. This was taken earlier this week, though, so we don't have ideal conditions for ozone production, but our monitor on the west side of Fort Collins continues to see high levels of ozone. This past August, we had ranges from 75 to 88 parts per billion. And EPA's current ozone standard is 70 parts per billion. Next slide, please. And as many of you know, the reason we're worried about ozone, we have a lot of health impacts that could create. Ozone is a clear odorless gas that goes undetected by our senses. So people don't know that they're really exposed to it. But when you inhale ozone, it reacts chemically within your body. So it can cause a number of adverse health effects. Most common acute ones that people are familiar with are like chest pain, inflamed lining of the lungs, reduced lung function, coughing. Repeated exposure to higher levels of ozone can permanently scar lung tissue. In addition, if you already have pre-existing conditions, this could lead to exacerbated conditions. It could also increase your sensitivity to other triggers. It can also increase in medication use, hospital visits, absences from school and work. Next slide. So what's contributing to our ozone here in Larimer County? As part of our ozone non-attainment status with EPA, Colorado is required to continue to evaluate our air quality, our pollution sources, and then the proposed controls, just to demonstrate that we're heading in the right direction with EPA's criteria. These pie charts were prepared as part of the ozone modeling overseen by the Regional Air Quality Council. And these help identify local emission sources and their contribution to ozone formation. So this helps us to then identify sources that could improve controls and theoretically have the largest impacts on ozone reduction. So RAC's ozone modeling has specifically demonstrated that ozone formation in Larimer County is sensitive to NOx emissions, specifically generated by the oil and gas industry. So looking at these 2 pie charts, we have the Fort Collins West ozone monitor, and we have the Rocky Flats monitor in Northwest Denver. In Larimer County, 34% of our ozone formation is contributed to oil and gas activity compared to the more urban area where Denver has 17% of their ozone formation is contributed by oil and gas activity. They're more heavily influenced by that yellow pie piece, which is light duty vehicles such as cars, transportation. Next slide. And as many of you know, Larimer County doesn't have a lot of oil and gas production within our boundaries, but we are adjacent to other areas that are more productive in this sector. The maps on this slide are from the 2014 Front Range Air Pollution and Photochemistry Experiment. Mouthful, FRAPE is the name of that study. Many of you are familiar. The study highlighted that oil and gas emissions generated outside of Larimer County eventually move westward. And this is due to the unique summer meteorology of upslope, downslope flows. This allows mixing of pollutants such as NOx and VOC emissions, and it gives them time to react in the presence of UV light and heat to create ozone along the Larimer County foothills. Next slide. Larimer County reviewed MRG's cumulative impacts forms. We noticed that there were 2. There's a Form 2B that was submitted in August 2022. And then we noticed a correction that was submitted in March 2023 that included non-road internal combustion engine emission calculations had been revised for the total production of the pre-production emissions at the site. Based on the most recent form in March edits, we saw that, and this is after the CDPHE consultation, that's the Colorado Department of Public Health and Environment, and MRG's commitment to several best management practices, specifically the use of electric drill rigs, and then all Tier 4 diesel engines for the non-electrified equipment. They still are predicting what appears to be 96 tons of NOx emissions and about 8.74 tons of VOC during the pre-production phase. It's probably about 25 weeks. I think I saw that on the application. Further review of the supporting engine calc sheets suggested about 80% of these estimated NOx emissions are from the 12 diesel completion engines proposed for each well. This would result in approximately 80 tons of NOx released over a short 2-month period during the completion phases. So Air Pollution Control Division would typically require a permit for a pollution source that emits over 25 tons a year of NOx. and as a major source, but these type of temporary sources are currently not permitted, and it is being evaluated currently with the Air Quality Control Commission and Air Pollution Control Division. But even though these pre-production phases are temporary, the emissions from the completion engines have the opportunity to contribute to short-term ozone exceedances if conducted during ozone season. This not only contributes to our ozone noncompliance with EPA, but more importantly, the health of our community as demonstrated through these slides and the impacts of ozone. Next slide, please. And we just want to highlight that the proposed summer delay of well completions utilizing fossil fuel engines is not unusual. It's not unique for us. After Governor Polis directed Colorado agencies to work together to reduce NOx emissions from the oil and gas sector, similar strategies have been proposed with Air Pollution Control Division and RAC, which include seasonal delays. Since the location proposed by MRG is not able to provide enough electrical power to electrify all their necessary engines, the operator has to supplement with fossil fuel completion engines at a minimum. Therefore, a strategic way to address the release of ozone precursors would be to plan for hydraulic fracturing outside of the ozone seasons. And we're thinking the peak ozone seasons of just June, July, and August. Next slide.
All right. Thanks, Leah. That was a great presentation. Matt Lafferty again here with Larimer County. Just to point out that Larimer County is not just looking at this from an oil and gas perspective, but from other perspectives. Air quality is an important issue to us. We do want to point out, though, that we have adopted some fairly substantial oil and gas regulations in the past 5 years. And we continue to work with the Air Pollution Control Division and other agencies to make sure that the state air quality rules are being implemented in a timely and meaningful manner. In addition to that, Larimer County is actively pursuing other issues in the area regarding leak detection as well as flaring that is occurring within the county still. And we've recently purchased a flare camera of our own so that we can go out and be performing some of our own leak detection activities and making sure that we're protecting our air quality here in Larimer County. And then lastly, Larimer County is in collaboration with our municipal partners here in Larimer County, as well as the APCD, have been installing and will be installing new regulatory ozone and NOx monitors in both Loveland, in the Timnath area, and along I-25. This will help us to better align ourselves with providing some better ideas on how to manage our air quality. And then finally, Larimer County is supporting the mow-down program through financial support. And the mow-down program is that opportunity for us to help the community move away from gas-powered lawnmower equipment and landscape equipment, which tends to increase the ozone issues in the county, and those occur primarily during the hot summer months. We also recently had our landscape provider here in Larimer County, who does our landscape work, commit to change their entire system. They're going to go to 90% of their system as being electronic equipment as a result of working with Larimer County. So in conclusion, I would just like to say we're asking that the commission consider asking or conditioning this application of MRG to operate any diesel engines or other fossil fuel engines or equipment during a time period outside of the peak ozone months of June 1st through August 31st. We appreciate the time that you've given us today. We do believe that MRG has taken a substantial amount of efforts to comply with all the rules, and we appreciate them and the city of Loveland giving us the opportunity to participate in this process, as well as the ECMC today. So with that, if there's any questions, we'll stop our presentation here.
Thank you very much. Does commissioners have any questions for the panel? Commissioner McGowan.
Thank you, Mr. Chair, and thanks for the presentation. And I think you all are focused in on the right things when we're talking about oil and gas development. I'm not sure I'm understanding the request because I feel like there's maybe some competing ideas here, which is that I think the operator is bringing electric rig to the table and Tier 4 engines for completions. And I think Tier 4 or better engines for non-road equipment, construction equipment. And those would be things that we would look for in the non-attainment area. So that I feel like, so that piece has been addressed. Are you also asking, even though they're implementing these, I will use the word best practices, are you also asking for the time restriction, or only if they cannot bring these best practices to the table, you're asking for the timing limitation?
We're asking that the time restriction be added to this. Yes,
Okay,
ma'am.
thank you. Have you all been participating in CDPHE's SIP rulemaking, ozone rulemaking?
Yes, we have.
And so you can correct me if I'm wrong. I think the draft proposal includes some of the ideas that you're proposing here, but I think during the high ozone season, part of the proposal allows for drilling as long as there's kind of in-use restrictions. So, and those are these practices that MRG is bringing to the table. Is that correct?
That's correct.
Okay, thank you very much.
Thank you.
Ms. Ryan, I see you visualized yourself. Did you have a point that you wanted to make or questions?
No, I'm just getting ready for when it's our turn for a presentation.
Okay, thanks. Other questions from commissioners? Great. Thank you very much, Larimer County. Appreciate you being with us. All right, Ms. Ryan, I believe you're up.
Right, wonderful. I believe all of our witnesses have been in panel. So for efficiency, if you'd like to swear everyone in before I kick it off.
Yeah, that'd be great. And while we're doing that, I don't know if there's a method to adjust your microphone, Ms. Ryan. You're coming across somewhat quietly.
Let me see if I can push it up.
All right, while you're doing that, Ms. Mercer, if you want to swear in the witnesses, that would be fantastic.
Thank you, Mr. Chair. I see you all turning on your cameras, which I appreciate. I'll go one by one in the order I see you on my screen and just ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Fanning.
Good morning, Tricia Fanning. I swear to tell the truth.
Thank you. And apologies for mispronouncing your name, Mr. Deshane.
Good morning. My name is Justin Deshane. I swear to tell the truth.
Thank you. I guess I got it right. Ms. Donahue.
Your mic.
If anyone who's not speaking could mute your microphones, that should help.
Good morning. My name is Jessica Donahue, and I swear to tell the truth.
Thank you. Mr. Dornbos.
Morning. My name is Ryan Dornbos, and I swear to tell the truth.
Thank you. Ms. Rowe.
I'm Erin Rowe, and I swear to tell the truth.
Thank you. Mr. Benton.
Good morning. My name is John Benton, and I swear to tell the truth.
Thank you. Mr. Miller.
Morning. My name is Joe Miller, and I swear to tell the truth.
Thank you. Mr. Irwin.
Good morning. My name is Bill Irwin, and I swear to tell the truth.
Thank you. I believe that was everyone.
Ms. Ryan, it appears that several of the witnesses may be in the room together, and we're getting a lot of feedback. That was Mr. Deshern, Mr. Donahue, and one other, maybe Mr. Miller, I'm not sure. But if we could just make sure that we've got microphones on and off appropriately so we don't get feedback, that'd be great.
Yes, thank you. Work it out. And I tried to switch to a different microphone. Can you hear me better now?
We can. Thank you very much. I appreciate it.
Okay. All right. Well, let's get down to business. Good morning, commissioners, staff, members of the public. My name is Julia Ryan. I'm a shareholder at Brownstein Hyatt Farber Schreck, appearing before you on behalf of MRG in docket number 2207-00198. Today, we'll be presenting the CE Pad OGDP application. We'd like to thank staff for their work on this application, including the director's recommendation for approval and CDPHE for consulting with us. We also appreciate the engagement with the relevant local government, City of Loveland, who has approved MRG's local permit, and the engagement with Larimer County, the proximate local government, who you just heard from. I'm going to address Larimer County's comments first, actually, before getting into the meat of our presentation, and then I will turn it over to the rest of the team to introduce MRG and go into our presentation, Chief. So next slide, please. Okay, so as Mr. Lafferty shared with you, MRG engaged several times with Larimer County throughout this process. And we had many productive discussions, and we were able to significantly narrow our issues. Initially, Larimer County had requested several BMPs, not just the single suggested condition of approval that it presented to you. And as you just heard from its presentation, the county's main concern is air quality. And so accordingly, the vast majority of the county's requested BMPs were related to air quality. For example, Larimer County requested electric drilling, and MRG clarified for the county that it was committed to electric drilling. MRG committed to every single request of Larimer County except for its request that MRG commit not to conducting completions activities during ozone season. MRG cannot commit to that request because MRG seeks to complete the wells as soon as possible and to minimize impacts by conducting completions in a single occupancy. Now, MRG did explore electric completions options, but unfortunately power to that area is simply not available. However, we are completing with Tier 4 engines. And because the area is currently agricultural, MRG seeks to complete the wells before any new development comes to the area. The current schedule does not have MRG drilling during ozone months, and completions, which again will be Tier 4, actually will mostly avoid ozone season in our anticipated schedule. We're aiming to conclude about second quarter, meaning we would avoid July and August of those ozone months. Next slide, please. I also think it's important background to appreciate that while Larimer County has made it clear its preference would be this condition of approval, but it's notable that the county doesn't take the position that it believes you should deny the application if the condition is not required. It's a preference of the county, but the county did withdraw its petition and does not oppose approval as is. The county has made a request, but not a protest. There are a few notable other undisputed points as well. First, the condition of approval Larimer County seeks is actually not even a rule in Larimer County's own code. It's not an ECMC rule, not a CDPHE rule, not a Loveland rule, and it's not required by Loveland's permit. Also, the ECMC has never before applied this condition of approval. Next slide, please. And third, Larimer County's condition of approval it seeks is something it has repeatedly asked ECMC for in the context of rulemakings, including the pending cumulative impacts docket. It's inappropriate to use an OGDP hearing, which should be about site-specific impacts, as a vehicle to advance positions of general applicability. Larimer County has had and will continue to have a fair and full opportunity to discuss its views at the cumulative impacts hearing and in other processes it told you it was involved in, such as a SIP rulemaking. MRG pointed out in its pre-hearing statement, and this was undisputed by Larimer County, that the Larimer County's language is taken from other ECMC dockets. And so this was just a quick sample slide to show you that this language is verbatim from things like, Larimer County's cumulative impact scoping comments, as well as this docket. So really, the condition of approval that Larimer County is seeking is one that it wants applied to every OGDP near it. Its position is not really about the CE pad specifically. The county did point out MRG's Form 2B emissions info, but the emissions are not unusual or out of the ordinary. They're exactly the numbers you'd expect for the wells involved and the technology used, and it's also in line with Form 2Bs on other OGDPs you've approved. So because Larimer County really wants a new rule, it should use the rulemaking proceedings to advance its position. Finally, I wanted to point out that your staff is fully aware of Larimer County's request, but did not recommend it as a condition of approval in the director's recommendation. I want to emphasize that MRG does appreciate the county's engagement and is thrilled we were able to agree on so many issues. This particular issue, however, is not something appropriate for an OGDP hearing. Next slide, please. Okay, just a few more preliminary remarks from me, and then we'll get going in earnest. There are no protests to this application, and MRG is very excited to share it with you today. This project has evolved significantly over the years to avoid, minimize, and mitigate impacts. What started as a concept involving up to 5 pads and up to 50 wells has now been engineered to just 1 well pad and just 15 wells. The development addresses public health, safety, and the environment through its many VMPs that exceed both your rules and CDPHE's rules, such as electric drilling and the use of pipelines. And these same measures are enforceable conditions of approval in the City of Loveland permit as well. We received a few commissioner questions in advance of the hearing and appreciate all those inquiries, and we will address all of them during the course of our presentation. I will now turn it over to Jessica Donahue, Regulatory and Permitting Specialist, who will introduce the rest of the MRG team and lead our presentation.
Thank you, Julia. Good morning, commissioners, staff, and attendees. I am Jessica Donahue with Ardor Environmental here today on behalf of MRG. MRG is excited to share the CE OGDP project with you today. Who is MRG? MRG is a name that might not be familiar to you because this is the first time it has sought an OGDP. MRG LP is a registered oil and gas operator in Colorado, operator number 10792, and is a managed limited partnership of the McWhinney Holding Company headquartered in Loveland, Colorado. To address a commissioner question received earlier this week requesting clarification on how many projects MRG has submitted to ECMC, MRG was originally pursuing 2 OGDPs, the CE OGDP we are presenting today, and a second project called the CS OGDP. The CS OGDP has been withdrawn, and MRG will not be pursuing a permit for that previously considered location. While MRG is a new entity, its team has decades of experience working in Colorado and the DJ Basin. Our team has successfully and safely drilled many wells throughout Colorado, including wells that were permitted, drilled, completed, and put on production since the mission change rulemaking. Presenting today, we have MRG's counsel, Ms. Ryan with Brownstein, Hyatt, Farber, and Schreck, who you've just met. Trisha Fanning and myself are with Ardor Environmental, and we will be presenting today. Additionally, with us to respond to commission questions are Bill Irwin, Ryan Dornbos, and John Benton for any engineering and operational questions. Aaron Rowe is available for geologic questions. Joe Miller with Mountain Air Consulting is available for emissions and air quality discussion. And we have Justin Duchesne is with us to answer any land-related questions. Today, MRG will present to you the CE OGDP project, its alternative location analysis, the permitting process and timeline, community engagement, and then we'll take you through a discussion of just some of the best management practices that MRG has incorporated into the project. As you heard Ms. Ryan mention, the original iteration of this project by a different operator contemplated up to 50 wells on 5 different pads. But one of MRG's many goals in planning this project was to reduce surface disturbance. So our team of experts redesigned the project to what's before you today. MRG is proposing a single location OGDP located in the southeast northeast of Section 11, Township 5 North, Range 68 West. The location will be accessed by North County Road 3. The location is situated north of Highway 34, which is also known as East Eisenhower Boulevard, and south of East Crossroads Boulevard. The oil and gas location will have an initial disturbance of 13.4 acres. With this OGDP, MRG is proposing 1 new drilling spacing unit. The OGDP includes 1,685 mineral acres. The project proposes 15 horizontal wells targeting the Niobrara, Fort Hays, Codell, and Carlisle formations. The CE project is located within the city of Loveland. The project has 2 proximate local governments, Larimer County and the town of Johnstown. There is 1 residential building unit within 2,000 feet of the location. The RBU owner has provided informed consent. The location was originally located within a disproportionately impacted community under the ACS 2019 5-year data. The map on this slide shows the CE pad designated by the red star within the ACS 2019 DIC designation in orange, and the updated May 2023 DIC designation shown as the red polygons. Under the revised May 2023 definition, the CE pad is no longer within a DIC and is located approximately 3 miles from the nearest DIC. The CE pad has an EnviroScreen score of 53.624. As mentioned earlier, the CE pad is located off North County Road 3, north of Highway 34. The proposed access road is 451 feet in length to connect the CE pad to North County Road 3. The image on the right shows the initial oil and gas location in the red outline, the working pad surface in blue, and the proposed interim reclamation and production location outlined in purple. The pad will be reduced from the initial 13.4 proposed acres of disturbance to a long-term production disturbance of only 5.2 acres. As represented on this slide, we have a simplified flowchart illustrating how the state and local permitting processes were navigated by MRG. The CE pad is located within the city of Loveland, which does regulate oil and gas location siting. Prior to submitting anything to ECMC, MRG met multiple times with the city of Loveland to discuss the project and coordinate the submittals between the two agencies. In addition to the city of Loveland Planning Department staff, several representatives from other city departments participated for a holistic review of the project. ECMC staff also participated in some of these early meetings. During these initial meetings, MRG and Loveland agreed that MRG would first submit their OGDP to ECMC. Upon receiving a completeness determination from ECMC, MRG then submitted the City of Loveland permit. MRG received its completeness determination from ECMC on November 10th, 2022. MRG submitted their permit to City of Loveland on December 2nd, 2022. Both permits wound their way through their respective processes. The CE pad permit met City of Loveland's enhanced standards, allowing the permit to be processed as a Track 2 permit. City of Loveland issued its final approval 20th, 2020. Effect in line with the local permitting process is the Centerra Design Review Committee. The Centerra Design Review Committee, or DRC, has an agreement with City of Loveland over certain aspects of permitting within the city. MRG has met with the DRC multiple times to discuss lighting and visual mitigation concerns. DRC issued its approval for MRG to finalize its Loveland permit on April 25th, 2023. Before MRG met with any agency, it voluntarily hosted a town hall meeting on January 19th, 2022, to initiate engagement with the local community and identify community concerns with the project. This town hall was hosted via Zoom, and over 400 people attended the informational meeting. As discussed on the previous slide, MRG then proceeded to meet with the City of Loveland and the DRC to discuss the project and submittal expectations. Larimer County considerations were presented at this time as well. MRG conducted an alternative location analysis due to the proximity of the residential building unit. This mineral development has been in the process for several years, and MRG has worked closely with the surrounding land developers to strategically locate and schedule development of the area in order to protect public health, safety, welfare, and the environment. Protecting the surrounding community, environment, and other receptors is paramount to MRG. Other locations identified as viable alternatives would have created more impacts to the local communities, wildlife, and environment. Here we show an overview map of the CE pad highlighted with a star and the alternative locations that MRG has evaluated. MRG identified 5 potentially viable locations as alternatives to the CE pad. To save a little time today, we're going to defer walking you through the individual alternative locations evaluated. All other locations evaluated did not provide additional protections of public health, safety, and welfare in the environment. We'll now skip ahead to the other sites that were reviewed but not identified as viable alternatives. In addition to the CE pad and its 5 alternatives, which appear to be unduly centered around the eastern portion of the proposed development area, MRG did evaluate potential locations along the western side of the project. However, due to the proximity of the airport, the hospital, and the established development, none of the potential locations offered more protection to the community and the environment than the preferred CE pad. Also of note, neither City of Loveland nor ECMC asked MRG to evaluate other alternative locations beyond those that were identified here. MRG's intention is to execute this project efficiently, with construction commencing upon approval, and the drilling and completion operations to begin shortly thereafter. This would allow for the wells to be producing by the end of the year of 2024, and interim reclamation activities to begin most likely in fourth quarter 2024. First phase is construction. As previously mentioned, the initial disturbance of the oil and gas location will be 13.4 acres. It is shown in this drawing as the red outline. The working pad surface will be 7.49 acres and is shown in the blue outline. The CE pad is anticipated to take approximately 3 weeks to construct. Topsoil will be removed and segregated from the surface, stored to be used later in reclamation activities as per the 1000 series rules. The CE pad will have stormwater controls and best management practices installed prior to commencement of construction to ensure all soil remains on location. The access road will be constructed to connect the location to County Road 3. Construction activities will be done during daylight hours. Once the location is fully constructed, sound walls will be put in place prior to entering the drilling phase. MRG intends to drill all wells proposed for this location in one occupation. Drilling will be a 24-hour operation, which allows for more efficiency and minimizes actual days of the drilling occupation. The anticipated total drilling time for all 15 wells is 90 days. Once drilling is completed, the rig will be moved off location. MRG has worked with City of Loveland to provide electricity to the location to be able to utilize electrified drilling rigs, which will minimize noise and emissions during drilling operations. MRG will use freshwater mud for the surface hole and then will use OBM for the rest of the wellbore. By using OBM for drilling, it significantly lessens drilling duration. OBM is recyclable and it allows operations to use less water to drill wells. One commissioner question received was if the operator would be willing to use Group 3 mud. MRG initially chose Group 2 mud based upon the uncertain availability of a Group 3 mud system. With the Group 3 mud systems being more readily available in the basin, MRG will now commit to Group 3. During drilling, noise levels for the area may be increased above normal ambient levels, but will meet ECMC Table 423-1 and City of Loveland Unified Code Chapter 7.32.040 levels. Temporary lights will be placed on location for safety reasons during 24-hour operations. These lights will be tilted downward and shielded as much as safely feasible. Water will be acquired from a third party. All water will be designated and permitted for industrial usage. No water will be obtained from potential drinking water sources. Once MRG has completed drilling, the location will move to the completion phase. Again, temporary lights will be angled downward and shielded. MRG anticipates approximately 90 days to complete all wells. As Ms. Ryan mentioned earlier, during the planning of this project, MRG did an electric load study and it was determined that the city electrical grid would not be able to support electric completion operations. Therefore, once all the wells are drilled, in lieu of electrified completions, a Tier 4 completions rig will be mobilized to the location to begin completing the wells. Traffic activity will increase in the areas during delivery of supplies, equipment, or personnel. And once completion operations are complete, this rig will be moved off location. During completions, noise levels for the area may be increased above normal ambient levels, but will again meet ECMC and City of Loveland requirements. To ensure compliance with these noise levels, MRG will utilize quiet fleet completions equipment. As with drilling, water will be acquired from a third party. All water utilized will be designated and permitted for industrial usage. And again, no water will be obtained from potential drinking water sources. Once all wells have been drilled and completed, the wells will be turned over to production. MRG has contracted with City of Loveland to electrify production equipment, which will reduce production emissions. No hydrocarbons will be permanently stored on location, only produced water. Produced water tanks will be in steel bermed lined containment that will hold 150% of the largest tank. Locations will regularly undergo audio-visual olfactory inspections. MRG will connect the location to third-party pipelines for oil and natural gas. One commissioner inquired regarding the potential for produced water pipeline takeaway. During the planning of this project, MRG did reach out to commercial produced water disposal operators in the area. There are no commercial produced water pipelines nearby. To connect the CE pad to a commercial water disposal facility would require the construction of an approximately 20-mile pipeline. Estimating future produced water numbers based on analogous production in the area, the produced water volumes will decline significantly after the first year of production. With the length of pipeline to be constructed and the knowledge that the water volumes will decline precipitously, the environmental impacts of such pipeline construction would greatly outweigh the potential impacts of hauling the produced water. MRG is committed to keeping limited produced water on location. Additionally, the potential produced water traffic did not pose a concern for ECMC staff, CDPHE, or the City of Loveland during the review of this project. Once the wells are producing, the location will undergo interim reclamation. MRG has developed a landscape plan to ensure the location will be bermed and visually screened as much as feasible from the surrounding area in accordance with the City of Loveland and Centerra Design Review Committee requirements. Shown here is a drawing of the location after interim reclamation and during the production phase. The purple box is the original oil and gas location. The green box was the original working pad surface. The pink outline shows the production pad after interim reclamation, which will be fenced in accordance with City of Loveland requirements and will be 5.2 acres. The circles and dots on the image represent future vegetation. From this image, it's tricky to envision what the completed interim reclamation may really look like, but on the next few slides, we have some visualizations. Here is a digital rendering of the view from above with the vegetation growth. This rendering is based off the landscaping plan that MRG developed in accordance with the DRC guidelines. This image is from County Road 3, the nearest public road during the interim reclamation phase, once the visual berms have been constructed around the location and the vegetation has grown in. And here we have a short video that simulates driving around the location after reclamation has occurred, so you can get a feel for what driving around in the area would look like. MRG believes in transparency for this project. Above and beyond what is required by law, MRG has conducted additional community engagement meetings as well as provided site tours with members of the public and press that were interested in the proposed project. Any person expressing interest in touring an oil and gas site was given a tour. One question received from the commission was regarding the future of the properties adjacent to the CE pad. There is other housing anticipated, but its schedule is quite far out. In fact, any residential development has yet even to be platted. MRG's drilling and completion schedule has those phases concluded prior to residential development moving into the area. Because the location will use pipelines, electrified production equipment, and have no hydrocarbon storage on site, impacts from production on any nearby residents are anticipated to be minimal. Future homebuyers will receive notice pursuant to Colorado Revised Statute 38-35.7-108, explaining that the surface estate of the property may be owned separately from the underlying mineral estate, and that owners of the mineral estate may have rights to enter and access the surface estate to access the mineral estate. As you know from your hearing portfolio, MRG received public comment from the nearest residents in support of the project. There were also comments sharing concerns. MRG has addressed these concerns in their best management practices and project design. MRG does take all community concerns seriously. The community has expressed concerns regarding water usage, water sources, and maintaining water quality. They're also concerned with air quality, potential impacts to wildlife, as well as financial assurance. A few of the operational and best management practices MRG has incorporated into their project to address these concerns are listed here, such as utilizing industrial designated water and temporary above ground pipelines for water delivery during completions. MRG will electrify drilling and production phases. Tier 4 engines will be used for completions operations. CDPHE requires a site to have continuous emissions monitoring for 6 months after the last well is drilled on a location. MRG has agreed to monitor these same emissions for 3 years after the last well is drilled. MRG is compliant with ECMC 700 series rules and will revise their financial assurance plan as per Rule 702 once their Form 2s are approved. The AQCC will be adopting a NOx reduction rule this December, which will focus heavily on reducing NOx emissions from pre-production drilling and completion activities. The rule is a response to Governor Paulus's letter calling for a 30% NOx reduction by 2025 and a 50% NOx reduction by 2030 from oil and gas operations during ozone season, May 1st through September 30th. Neither the governor nor the APCD have proposed a seasonal restriction to address the targets, and the state's proposed rule will ensure that the targets are met. The list of reduction practices in the APCD's proposal represents state-of-the-art best technologies available to operators to reduce NOx during drilling and completion activities. MRG's proposal meets what the Air Division has proposed, specifically by using electrification for drilling activities and Tier 4 diesel engines for hydraulic fracking operations. MRG's plan goes even further, however, by ensuring production activities will be electrified and will be oil tankless. Neither are regulatorily required, meaning MRG will be achieving additional reductions over and beyond what is required. The rule proposal will also establish a steering committee to study further reduction opportunities, including more widespread electrification to ensure the 2030 targets will be achieved. MRG agreed to go above and beyond the monitoring duration for Regulation 7 continuous emissions monitoring and has committed to monitor emissions for 3 years after the last well is drilled. Regulation 7, again, only requires 6 months of post-drilling monitoring. Water for completions operations will be piped to location via temporary surface pipelines, eliminating approximately 2,250 truck trips per well, or 33,750 trips for the project. MRG will have pipeline takeaway in place for oil and natural gas. As mentioned earlier during the electrical load study with the city, it was determined that they could not provide electricity for completions operations. MRG has therefore committed to using a Tier 4 completions rig. MRG has also committed to deferring all routine, non-essential activities during high ozone days. MRG will use closed loop drilling and will haul cuttings off regularly in covered trucks. MRG will use a squeegee or other means to remove drilling fluids from the drill pipe as it exits the wellbore. MRG will use Group 3 mud that will be stored in enclosed tanks. Within 24 hours of receiving a complaint, MRG will implement odor neutralizer agents. And another key thing is that MRG does not intend to store these drill cuttings on location for long periods of time. MRG will have stormwater controls in place at the time of site construction. CDPHE requires stormwater inspections to occur every 14 days, with additional inspections required after a stormwater event within 24 hours. Or an operator can commit to inspecting a site every 7 days with no additional event requirements. MRG has committed to conducting regular stormwater inspections every 7 days, as well as conducting additional inspections within 24 hours after a stormwater event. MRG will utilize a closed loop system for drilling and will only use freshwater for dust mitigation. No PFAS will be used on location, of course. And MRG, as mentioned, will only use sourced industrial water for downhole operations. No municipal drinking water or fresh water will be used for MRG operations. MRG will utilize OBM, which reduces our water requirements and creates a more efficient drilling process. MRG will utilize noise mitigation on site for drilling and completion operations. MRG not only modeled for production equipment proposed for the immediate future with the current surrounding environment, but additionally modeled for potential future development on the adjacent properties, as well as potential future production equipment. MRG developed a lighting plan and incorporated a lighting design that meets ECMC, City of Loveland, and Centerra Design Review Committee requirements. Dark sky lighting features will be used for production operations. All lights will be warm in color to minimize their impacts across the landscape. As I mentioned earlier, water for completion operations will be brought to location via temporary surface pipelines, which will reduce traffic. And the location will have, of course, oil and natural gas pipeline takeaway to further reduce truck traffic. The CE pad is a single location that is protective of public health, safety, welfare, and the environment, while also being the most efficient access to the targeted minerals. Previous iterations of this project had initially intended to construct multiple locations to access the same mineral development area. MRG has worked with the City of Loveland to confirm electricity for the site and reduce emissions. MRG will implement continuous emissions monitoring at the location for 3 years after the last well is drilled, as per the discussion with City of Loveland. And by having telemetry at the location, MRG will be able to schedule site visits efficiently while still having constant data, updating team members of everything occurring at location. MRG has been working to develop an efficient drilling project while protecting public health, safety, welfare, and the environment. The CE location has limited receptors and will employ several BMPs going above and beyond the state's rules, including, among other things, conducting the air monitoring for 2.5 years, longer than required by the state. MRG has no concern with staff's recommended condition of approval, which states after topsoil pits have been dug and documented, prior to beginning construction, operator will submit
Jessica,
soil.
you're frozen for me. Is anyone else frozen?
I'm able to hear you.
Chair Robbins, can you hear me?
I can hear you, Ms. Ryan. Yes. I'm not having any problem hearing Ms.
I
Donahue.
apologize. One moment, please. I can no longer hear you.
Okay, I'll continue then. Thank you. As I was saying, MRG does have no concern with the staff's recommended condition of approval regarding submitting this topsoil test pit dated ECMC via the Form 4 sundry. Estimated quantities of topsoil with height and slope of the stockpile will be included. Once Ms. Ryan has rejoined us, I will turn it back over to her.
Ms. Ryan, are you with us? Commissioners, why don't we take 5 minutes?
Hi, excuse me. This is Julia Ryan. My colleagues have informed me that they can hear, and I think this may have been related to my microphone switch. So I am going to call in on my phone, and I sincerely apologize for this issue.
Okay, let's take 5, give Ms. Ryan a chance to call back in. Let's return at 10, I don't know, 57-ish. All right, Ms. Ryan, are you back with us?
Yes, I'm certainly glad the day-to-day operations will be run by engineers, geologists, and people with much better tech capacity than myself. So I appreciate your patience.
Yeah, no problem. Do you want to run through this last slide of requested relief?
Yeah, I'll just wrap up so quickly here. You know, the presentation you just heard and the other elements in your record demonstrate that this OGDP complies with the Oil and Gas Conservation Act, meets or in many instances exceed the Commission's rules, and protects public health, safety, and the environment. We respectfully request that the ECMC enter appropriate orders approving the requested relief in the amended application, a new 1,685-acre drilling and spacing unit for the development of up to 15 new horizontal wells from the Niobrara, Fort Hayes, Codal, and Carlisle formations, providing that the subject wells shall be located on the CE pad within the application lands, and approving the Form 2A for the CE pad. And finally, finding that the CE pad OGDP will protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on air, water, soil, or biological resource in accordance with state statute. We are all available to answer any questions you may have, and thank you for your attention.
Okay, thank you for the presentation. It was very thorough. Very much appreciate that. Commissioners, the panel is open for questions. Commissioner McGowan.
Thank you, Mr. Chair, and thank you for the presentation. It was helpful. I guess I didn't notice the picture where the pad is and the entry access road is on the northeast. I think that's the northeast side of the pad, which seems like it's closest to the nearest residence. And I'm wondering why it's on the northeast side and not the southeast side if my directions are straight. I mean, you have traffic coming in and out right across the street from that RBU versus a little bit further south.
Ms. Donahue.
Thank you for the question, Commissioner. The road is, you are correct, the road is on the northern side of the location. It provided the more efficient route for drilling completions to be in and out and safe with where the rig would lay down and how it would move across the pad to drill the wells. And then once the location is on production, as you saw from the pictures, the northern side of the pad, there will be berms and such so that the road piece itself will be a very slight disturbance on the north side.
Okay, I guess all the trucks are going to be coming in and out of that access location, and it's right next to the RBU. And I assume that you've talked to the RBU owner about this.
Correct. The RBU owner is aware of the pad design.
Okay, thank you. So in looking at Loveland's permit, it looks to me like it's low density residential platted all around this location. And I think what I heard you all say is it's not platted yet, but are locations being sold at all yet? I think the public comments that were submitted when this was a 2-location proposal, I think the residents felt like they did not understand that there was going to be oil and gas development near their homes. I'm just wanting to understand how near we are away from the areas around this location being developed.
I'll take that question, Commissioner McGowan. So a lot of the record's a bit confusing here because a lot of the public comments concern the CS pad location, which was withdrawn. And so those residents are far from CE pad, generally miles, and they also did receive disclosures. They received a disclosure statement in their home buying materials, and they were also required to sign an acknowledgement verifying that they had read and understood that disclosure. There's also statutory notice that's provided under CRS 38-35.7-108. explaining severed minerals and different surface rights that may be accessed. So that's one piece of it. And then in terms of this newer development, as you said, it's not platted. So this is quite a bit further out. And of course, any new residential development that may come at that point, the pad will be on production. So the most impactful phases will have been completed, but also those homeowners will also receive the statutory notice, and those buildings will also be subject to City of Loveland's reverse setbacks.
Thank you. So I get that we have requirements and people are supposed to read their stuff, but we all know that if anyone's ever closed on a house, there's a lot of stuff to read there and a lot of things that folks don't understand about severed minerals and or whether or not oil and gas development is going to be coming to their location. So if it's far enough out so that whoever's going to buy a house next can already see what has happened at this location, I think I'm fine. If folks are going to be purchasing property, anticipating building a house before you have built out your location, I'm wondering if you're open to putting up a sign that says this is a future location for oil and gas development until it's built out, with a phone number of who to locate and ask questions to. Does that make sense what I'm asking?
Yes, I'm just, I'm conferring. That sounds like a reasonable request. Let me repeat it back to you so I understand. You're just suggesting a sign on the location indicating that'd be a future oil and gas site. I feel that's appropriate. I'm not getting any virtual kicks under the table from my client.
Okay. And by a sign, I mean something bigger than I have to drive up to the location to see it. I know if I'm going to buy a house in this area, I can see some sign. I'm like, okay, there's something that's going to happen here where I might be buying a house. So just think about it. You don't have to answer now. And let me know what you think. I also, this is a really weird situation that I've not been confronted before as a commissioner also, in that this is a new operator. And so right now there's only a $60,000 surety bond because you all haven't built anything yet. And so I'm wondering if you all are open to turning in your Form 3, which is your financial assurance plan, at the same time that you turn in your first Form 2, which is your signal to us that you're getting ready to drill. Because I don't want there to be a lot of lag time between this operator having a financial assurance plan that's been adopted by the commission.
Good morning, Commissioner Gowan. Tricia Fanning with Ardor Environmental. MRG is committed to being compliant with the 700 series rules for financial assurance, which does require us, upon approval of the Form 2s, to be fully compliant with the bonding requirements. So we will be submitting, once we actually have wells, which are subject to the rules of the 700 series, a Form 3, which will be the avenue for which we will have to bond associated to the approved APDs, which also require a $100,000 reclamation bond for the location. And at this point, it'll be approximately $40,000 per well.
Right. And I'm asking if you can move your financial assurance plan up.
I think I'm trying to understand the request of up because it's required.
So when you turn in your Form 2, you haven't started drilling. You're saying I'm going to start drilling, and you know you have 15 wells. And I'm going to guess that you have an assumption about production already.
Well, when it's a new well, it's a single well financial assurance for all wells. So it's not based on BOE initially. So the requirement will be full cost bonding per the rules. So we will be required to do that on approval of our APD. We won't have a vessel to be able to do it in advance because the system is triggered when you have an approval of an APD. The bonding that MRG has already provided is currently compliant. So once
I see what you're saying. I understand what you're saying, Ms. Fanning. I'm asking, I have concerns about you being bonded for only $60,000 right now as a new operator with no experience in Colorado, no history with us, no track record. I know you, right? But I don't know the work of this group, this brand new group. And $60,000 is, for this commissioner, concerning. So I'm trying to figure out how we get your financial assurance plan up and running as soon as possible. And so I guess I'm just, I was talking with AAG Mercer yesterday to try to figure out some way within our rules to make that happen. And that's the only thing that I could think of.
I guess, excuse me. As a third party observer, I believe you two possibly may be just speaking past one another. Commissioner McGowan, I understand your point to be there's only 60,000 now. We want to make sure that there's adequate bonding in place when these wells exist. What Ms. Fanning is explaining is that happens when we get our Form 2. So as you all know, we get the Form 2A approved, but Form 2A just allows you to have the location. It doesn't allow you to drill a well. And so there aren't wells to protect until they're drilled. But as soon as we have that, if the request is to have that financial assurance in place before we drill a well, that is fine. And it's in fact what we're proposing. So the bond will be fully in place. I think maybe there's just a little bit of confusion on the sequencing, but yes, the bonding will be in place before wells are drilled.
I think that would be helpful. And then I guess I would ask of our staff if we can move this financial assurance plan to the top of the pile so we can get it approved timely. And that would be a request from our own staff. I think that's all I have for now. Thank you.
Professor, I was going to say Professor McGonagall, Commissioner McGowan. I wanted to circle back quickly to the sign because we want to be compliant right out of the gate. My understanding is that when those future homes, eventually exist, they're going to be at least 4,000 feet away, so quite a distance. And I know we're currently planning on having signage that's compliant with your requirements as soon as construction commences, and that'll have contact information. Will that be adequate for what you envision?
The signage that gets put up on sites is pretty small. You have to kind of understand what's happening until you see drill rigs there and then know what's occurring. I think my concern is, even if something is 4,000 feet away, understanding how people feel when they buy a house, they kind of want to know what's going to be in their neighborhood. And the original comments when you had this other location as part of your OGDP, right, but dropped it because now you've consolidated things, is people thought they were purchasing one thing and then were surprised that this other thing was going to be occurring. And I don't want this to happen to future homeowners that might be building their house around this location if they purchase their location before you all start drilling. I guess that's my concern.
Oh, I see. Well, if that's your concern, then hopefully I can put it to rest, because those public comments were concerned about the drilling and fracking stages.
Yep,
and so here that's not possible because of our anticipated schedule. Homes are that the drilling and completion phases will be completely done by the time new homes come into the area. And because we have no tanks on site, we're using pipelines, everything's electrified, the impacts will be, it's very difficult to imagine how they would even really know of the facility, quite frankly, with the robust landscaping that's planned.
Yep. Okay. I guess another question I forgot to ask is this the only location that's anticipated after, because you all dropped the other location, or is there an anticipated future location somewhere in this development area?
Not to my knowledge, and certainly the CS location is no longer on the table.
Yeah, thank you. Thanks.
Commissioner Messner.
Thank you, Mr. Chair. These questions are, I think, both for the applicant, but perhaps AAG Mercer or another member of staff. I'm trying to determine whether the Form 2A attached to the director's recommendation is the Form 2A that's the most current version of the Form 2A that we're reviewing here today.
Commissioner Messner, that is my understanding. I would invite staff to chime in if that's incorrect.
Okay, well, if that's the one that we're working off of, I've got a few different questions. And as I look on page 11 on the Form 2A, which are the operator proposed BMPs, there's a few different things that I'm seeing here. And one is, and give me a second here because I'm going through it. One is towards the end of page 11, tankless design. It indicates that operator will not store produced water or hydrocarbon liquids in storage tanks on site, other than a maintenance tank possibly used for well unloading or other maintenance activities. What I'm hearing the operator say is that they will be storing produced water on tank and they'll be trucking it away. And so I'm trying to better understand what the intent of that BMP is if the operator is now indicating that they're not going to do that.
I can take that question. Thank you, Commissioner. I'm just pulling it up so that I'm looking at the same item that you are. The intent of MRG has always been that the location is going to be tankless, as in there will be no hydrocarbons stored on location. It has always been designed with produced water tanks on the location.
So is this not one of the BMPs that you've proposed though?
So the way the 2A works is as the submitter, I do not put BMPs on there. The BMPs are added by staff as they go through the plans and other items that are submitted. So if it was,
Which I guess what I'm reading, what I'm trying to sort out here is that we need the Form 2A, which is the enforceable BMPs associated with this application to be accurate. And right now, at least what I'm reading is that the operator will not store produced water in tanks on site. If you're indicating that that's something different, I'm trying to figure out what the remedy is. There's a few other, things that are similar to that. On page 12, there's one BMP that says operator will use tier 1 or tier 4 or better engines for drilling, and then there's another one two lines down that indicates that the operator will use electric drilling rigs. To me, those two things conflict, and so I feel like that needs to get sorted out on the Form 2A. There's another one on page 11 that talks about that the operator is let me find it here. Give me just a second. Well, it's on top of page 12, actually, that says the operator will use pipelines to transport water for hydraulic fracturing to and from location. And so maybe someone can help me how to best sort this out, because I think what's on the Form 2A is not what the operator is indicating that they will do.
Commissioner Messner, if I may, in my view, the appropriate way to remedy this would be to get clarification from the operator of, what really these BMPs should say to conform with their plans. And then in any motion or, deliberations, give specific direction to staff to correct the specific BMPs accordingly.
Okay.
And excuse me, Commissioner Messner, I'm doing a quick spot check as well. And I'm hoping that only those two limited instances, the last one you mentioned about pipelines, that's the water it specifically says the water for hydraulic fraction. It's not the produced water. So I think just a small nuance there.
I do understand that. I mean, I think I'd like some clarification on that, because it can be interpreted as hydraulic fracturing water, which is produced water, is intended to be piped from location.
Commissioner, I think we can work with staff to clarify anything that may be discrepancies. Some of the, I think specifically some of these BMPs that seem contradictory are from I like to call it the default menu of BMPs that we get during an operator would receive from CDPHE during consultation. So while we had discussed with CDPHE the clarifications regarding these, such as the default language says tankless, we want to clarify that it will be hydrocarbon tankless, but we do need to store produced water on there. Perhaps somewhere between the initial discussions with CDPHE and the insertion of the BMPs onto the 2A itself, there may have been some of these nuances may have been lost in translation.
Okay. Yeah. I mean, I'm happy to leave it in as is, but so I mean, the obviously the burden's on you to ensure that the application that you've presented and that you're presenting is accurate, and that the Form 2As are accurate. But I do think that what you're saying clearly in your presentations is not what's being reflected in the Form 2A. And so I do just want to make sure that that's accurate, so that we have an enforceable BMPs associated with the Form 2As. And then, I mean, help me understand this a little bit as well. And so I think we've got some concern from particularly approximate local government around activities, particularly with tier 4 diesel engines associated with high ozone days. And I think I understand the argument here, and I understand the responses to it. But as I think as you indicated, and as I put the clock to it, what you're proposing is to more or less be complete by second, third week of June. And so if that's the case and that's what you're proposing, is there some opportunity to be able to provide that certainty to approximate local government that has these concerns by codifying that construction timeline that you've proposed in your application?
Commissioner Messner, I'm a little queasy with codifying it because we already feel like we've given so much and we're able to work out so many of these issues with Larimer County. And while that's certainly what we anticipate, we wouldn't want to find ourselves in a non-compliant situation because of a rig availability issue or a workforce issue, or because precisely because we're avoiding ozone months. We're going to be in the winter season. Colorado has a crazy March storm that we sometimes have, something like that. And so we're not comfortable making it a hard commitment. And it's not something that's ever been committed to in your rules before. We think in this instance, it would be unnecessary and unreasonable given the other measures we're implementing.
Okay, thank you for that response. I'll have thoughts on that during deliberations, but you've answered all my questions. Thank you.
Other commissioner questions? All right, I'm not seeing further commissioner questions at this time. Thank you to the panel for answering our questions and for providing us with your perspective. We now will turn to commissioner deliberations. Does any commissioner desire to initiate deliberations? Commissioner Messner.
Thank you, Mr. Chair. I'll start out with my deliberations with, I think that there clearly was a lot of work done by this operator, both in the consideration of the application and outreach to community, coordination with relevant and proximate local governments and affected parties. I think it's important to note that this application is being reviewed, with one RBU inside 2,000 feet, but that RBU owner is signed informed consent. There's no other RBUs inside 2,000 feet on this particular location. I think besides the lack of consistency in the Form 2A, I think that the operator has generally clearly indicated what they're intending here. I think the city of Loveland has placed specific expectations on technologies and siting and other considerations for BMPs on this operator in order to ensure that the operator is able to meet the requirements associated with the local government's oil and gas regulations. I think a lot of those BMPs also apply directly to some of the considerations that we have in our regulatory considerations. So I do think that many of the BMPs that are being proposed are best in class BMPs for an operation like this, and so I really do appreciate that aspect of it. And so I guess the long and short of it for me is I do find that this is an approvable application. Now I'll make a side note on this because I do think that the approximate local government, Larimer County, does have legitimate concerns associated with potential impacts for air quality in their particular jurisdiction. I think Commissioner McGowan, you asked good questions when you asked whether or not some of the things that are being proposed here are things that are being considered as best management practices within a rulemaking that's being undertaken by our sister agency. And I think that is true, that a lot of these things that are being proposed are the exact types of technologies that are being considered as kind of best in class, best management practices for a lot of the non-attainment area. I do though think that there was a potential here to actually have some consideration for being able to look at different timing scenarios in order to be able to miss the non-attainment area, particularly in a situation where you had an operator that certainly I think was willing to utilize electric power for its hydraulic fracturing operations, but the electric power wasn't available, and so was going to need to use diesel engines. And so, you know, that preamble that was given by Ms. Ryan at the beginning, as far as responses to Larimer County sharing their concerns and their request, you know, at this stage to, you know, consider timing stipulations or construction activities that may be outside of that high ozone time, I think was a reasonable ask. And while it was couched as another way of providing comment towards cumulative impacts rulemaking, in this commissioner's opinion, I certainly don't see it as that. But I also will indicate that, you know, OGDPs that I review and outcomes of OGDPs and operators' proposal inside of OGDPs certainly do create a basis of opinion for this operator on what needs to occur in cumulative impacts type rulemakings or any future rulemakings. You know, this is a good example for me of how some voluntary best management practices may not be the best approach on how to address cumulative impacts in the future. But having said that, in this particular application, I do believe that the application meets the rules and do support it.
Thank you. Others with deliberative thoughts? Commissioner Ackerman?
Thank you, Mr. Chair. Not really a whole lot to add. Appreciate Commissioner Messner's comments here. And I do think that, you know, this is an issue that we continue to talk about is drilling during the high ozone days, something that we're very sensitive to and having significant discussion about along with CPHE. I would agree with the operator that I think that they have done, and with Larimer County, that they've done significant coordination, work together on a number of issues. And this is something I very much appreciate and like to see. I appreciate the commitment, significant commitment to use electric drill rigs, Tier 4 completion engines. And I feel like the operator has done what they need to do in order to make sure that this application fits within the scope of our regulations. I would also note that, you know, we'll continue to have conversations about the impacts of drilling in the non-attainment area and the minimization methods that we're currently using and whether those are sufficient for the oil and gas sector, whether new gains continue to need to be made. I don't know that the OGDP level is the appropriate place for that discussion. I wouldn't be in support of mandating that at this time.
Thank you, Commissioner Ackerman. Does anybody care to make a motion? Commissioner Messner?
I mean, I'm happy to make a motion, but there's enough changes that are being considered in this application that I'm going to need some help from AAG Mercer as far as how to best incorporate at least 4 things that I'm seeing, which are now a commitment to Group 3 drilling mods, changes in language in the Form 2A BMPs associated with produced water tanks, hydraulic fracturing water takeaway, and now I'm forgetting what the other one is, and so I have to actually look it up here because I can't remember now.
AAG Mercer, do you have some thoughts here?
Was the last one the commitment to post their bond before they commence drilling?
No, that was actually another one that I forgot.
There was the signage one.
There was the signage one, and then there was the duplicate BMPs in there, where one BMP says the operator will use Tier 4 or better engines for drilling, and then another BMP in there that says operator will use electric drilling rigs.
Yes. So if I could try to articulate all of that. And actually, I would like some clarification regarding the signage item. I wasn't sure if that was something that was agreed upon or if that concern was resolved.
Ms. Ryan?
I was actually a little bit unclear on that as well, because when Commissioner McDowell and I were having the exchange, we were talking about how the notice aspect, or at least what I was trying to say is the notice aspect raised in the comments was the people concerned about drilling completions happening. And then we discussed at length how for this pad there won't be drilling and completions until those will be concluded before new residents come into the area. So it's just not the same concern. These other public commenters didn't say we were worried about existing production when we moved in. The comments were concerned with drilling completions. So it's not present there. And 4,000 feet. However, I hope we communicated through our presentation that transparency is incredibly important to us. So I would suggest maybe a 4x8 sign, something pretty large, if that's acceptable.
With that clarification, Commissioner Messner, would you like me to try to articulate the various aspects of the motion that I believe are at play?
Sure, you can actually craft the motion if you'd like, and I'll say I agree.
Okay, so what I'm hearing is a motion to approve the application with the following changes. The first would be adjusting or revising the Form 2A in the following ways. So on the bottom of page 11, the BMP that says tankless design, operator will not store produced water or hydrocarbon liquids in storage tanks on site. That should be modified to strike produced water or and only refer to hydrocarbons. Next would be the BMP at the very top of page 12 should be amended to say operator will use pipelines to transfer water for hydraulic fracturing to location and strike and from. Farther down on page 12, we should strike the BMP that says operator will use tier 4 or better engines for drilling. Leaving in place the one that's 2 down that refers to electric drilling rigs. I believe those are the changes to the 2A. And then I have recorded 3 COAs that should be added. The first is a commitment to use group 3 drilling mud. That will also need to be corrected on the 2A because there is a reference to group 2 muds. The second is that the operator commits to posting their required financial assurance prior to commencing drilling operations. And the third would be the operator's commitment to post a 4-foot by 8-foot sign at the location indicating that it is a coming oil and gas location. Commissioner Messner, did I capture everything?
To my knowledge, you've captured everything. And so I would make that, well, clearly that's not accurate. So
why don't we hold off on a motion? We've got it in our back pocket. I saw Commissioner Ackerman first and then Commissioner McGowan.
Thanks, Mr. Chair. I was just clarifying on the staff proposed COA too. We haven't talked about that. Don't know if that needs to be included in the motion that requires the submittal of soil test pit data on a Form 470 after topsoil.
Thank you, Commissioner Ackerman. That COA is already noted on the Form 2A, so doesn't need to be added at this time.
Good check, Commissioner McGowan.
Thank you, Mr. Chair. I was just wondering, I don't know if this could or should or would be included in the COA. I'm just wondering if staff is able to, once we get the financial assurance proposal from the operator, get that approved timely. I know we've got a little bit of a backlog still, so I just want to make sure that staff's okay with that.
I think that's more of a direction to staff. And I think at least from my mind, that's not something that would be an imposition on the applicant. Hey, look, there's Director Murphy raising her hand.
Yeah, thanks, and apologies for having my video off. We will make that happen.
Thank you.
I appreciate the direction. Yep.
And I'd agree with the chair that that's not appropriate to add to the 2A. We should keep the 2A to the operator's commitments.
Okay, but we have duly noted from the director that that will happen. So the point is raised and made and is dealt with. All right,
so,
I think
AG Mercer, I just wanted to make sure because I might have missed it, but did you indicate that the operator is committed to the utilization of Group 3 drilling mud?
Yes.
Okay, I thought. So, Mr. Chair, if I may, with that, I would I would move approval of the application with the language that has been provided by AAG Mercer.
We have a motion. Do we have a second?
Second.
Motion and a second. Is there further discussion on the motion? Hey, Ms. Ryan, before I call the vote, is your client comfortable with how we've articulated the motion?
Yes, thank you.
Okay, thank you. All right. All those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thanks to everyone, including our staff, for the good work here, including the applicant. I want to appreciate the applicant working with the city of Loveland. I think that was a critical component to this, and appreciate AAG Mercer helping us out with the motion. So with that, we are done with this matter. We still have two matters to take up. I'm going to push us along because we've got some other things that we need to take care of, but I've lost my agenda. Hold on. Now we have an oil and gas development plan, Bison 4 operating, docket 230500235. And to begin this matter, I believe we should recognize Jason Maxey, the director of the Weld County Oil and Gas Energy Department and its LGD. Commissioner Cross?
I think we may have lost Commissioner Ackerman.
Hold on just a second, Mr. Maxey. I may have lost two of my commissioners. Maybe pushing this along was not a great idea. Oh, there's one. I know Commissioner Ackerman is traveling and taking.
It said he just messaged me and said he got demoted out of the panel.
That's what happens. All right. Hearings Manager Thomas, if you could re-promote Ackerman to the panel, that would be excellent.
He's on
there. He is. Thank you for keeping track of us, Commissioner Cross. Appreciate that.
Apologize, Mr. Chair. I was demoted, but I think I have since been re-promoted.
You are re-promoted. All right. And I know Commissioner McGowan is listening in with video off. So, Mr. Maxey, you are recognized.
Yeah, it's still morning, so good morning, commissioners. Thank you, Chair Robbins, and Commissioner Ackerman. Yeah, I don't know. I get promoted and you get demoted, so I don't know. Take that as you will. Well, thank you, as always, for being allowed to speak for a few minutes to you this morning regarding the OGDP item that we are now on your agenda for, which is the Bison 4 Boom Hog 8-59 3 location. Just wanted to say a few things regarding the Weld County process and a few highlights for dates and things like that you all are normally familiar with us getting on and relaying during this kind of public interaction, so to speak. We held our pre-application meeting for this location on November 23rd of 2022. At that pre-app meeting, as per our normal process, there were multiple alternative sites that were discussed based on the information submitted by Bison at that time. Attendees to our pre-app meeting, as standard, included Weld County staff, Bison staff, ECMC, and CPW. CPW was invited, but they did not attend the pre-app meeting. They were on the distribution list with the meeting minutes, however, so they got the full rundown of how that pre-application meeting went. So actual attendees, again, were Weld County, Bison, and ECMC. We received the 1041 WOGLA application on June 6th of 2023. And within that application, as is standard, there were multiple analysis of alternate sites, which were reviewed and discussed in detail with oil and gas staff, as well as the hearing officer when it went to hearing. As per our normal process, again, we sent out multiple referrals to agencies on July 21st of this year. We did receive responses from Weld County Departments of Environmental Health, Planning Services. We did receive a response from Colorado Parks and Wildlife, from ECMC, CDPHE, and from our Weld County Office of Emergency Management. We did not receive responses from the fire district, although they did participate in our emergency response plan, and that is included in, as always, with our WOGLAs, and so that's a part of the overall permit. We also did not receive any response from the BLM since they had areas that were in close proximity. We sent a referral to them, but we did not receive anything back. We also did not receive any public comments on this application. We did not receive any requests to participate in our hearing process from anybody in the public who was notified either. We held our hearing on September 14th of 2023. And at that hearing, as normal, the hearing officer considered testimony, and at the conclusion found the application to be complete and compliant with Weld County Code requirements and approved the permit. Now, one thing I want to call out to you on this one here, I'm not too sure who all reads the final orders at the ECMC, and if nobody does, that's okay. But I just want to call to attention one item in the final order and talk about the process for just 30 more seconds here regarding how we look at these and our interactions with others throughout the process. In the final order, there actually, along with multiple other items that were ordered, there was one item that specifically calls out burrowing owls and that the permittee, Bison, shall conduct a burrowing owl survey prior to construction if the construction phase operations will take place during the nesting season. I just want to call that out real quick and highlight how serious we are about our referral process and our partnerships with other agencies, and how you all know that we review and evaluate the details of each permit we consider, no matter how populated an area is within the county, or in this case, how remote it is. There's always location-specific land use factors for each permit, and we take great pride in our WOGLA process. The final order was recorded with our clerk and recorder on September 21st, and it was published in the Greeley Tribune on September 23rd. From a land use perspective and from our review, we believe this is a good location. It is close to other oil and gas development, and it is in a remote area. We submitted our 2A comments to you all on October 20th, and they are included in your director's recommendation. We have received the director's recommendation, and we have read it, and we agree with it and support approval of this permit. So with all that being said, I appreciate the time as always. And if there's no questions, I will remain active on the Zoom call. And Commissioner Robbins, you know how to get a hold of me if there's any questions.
Questions for Mr. Maxey. Again, Jason, appreciate you being present and appreciate the Weld County review of this and providing its perspective to us. As we noted earlier today, the relevant local government input is important, earlier from Loveland and now from Weld County. Any questions? All right. Seeing no questions, Mr. Prashala, good morning. Still morning by 17 minutes. Will you please raise all of your witnesses to the panel, and we will have AAG Mercer swear them in. I see a Miss Gillen and Mr. Hogan. Do you have others? You're muted, Mr. Prashala.
Apologies. No, Ms. Gillen and Mr. Hogan are the two witnesses from Bison.
AAG Mercer, let's do some swearing. You're muted too, Ms. Mercer.
Wow, my apologies. You'd think we'd have this all figured out by now. So to the members of the panel, I'll just ask you one at a time to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Gillen. If you could just state your name and that you swear to tell the truth.
All right, I thought you were going to ask me to first. Oh. My name is Katie Gillen, and I swear to tell the truth.
Thank you. Mr. Hogan? You're on mute.
Sorry about that. My name's Ian Hogan. I swear to tell the truth.
Thank you.
All right, Mr. Prashala, the floor is yours.
Yes, thank you, Mr. Chair, and good morning, Commissioners, Director Murphy, and staff. As you know, my name is Joe Prashala with Wellborn, Sullivan, McIntooley, and I represent Bison 4 Operating LLC. This morning, we're presenting the Boom Hog 859-3 Oil and Gas Development Plan, and I'd like to thank staff for all of their work on this application, as well as Mr. Maxey for his work and supportive comments that we've heard earlier. Presenting for Bison today are Katie Gillen, Director of Regulatory Affairs and Environment, Health and Safety, and Ian Hogan, Vice President of Exploration and Geology. Bison's application requests the Commission to approve an oil and gas development plan that covers approximately 2,682 acres within Township 8 North, Range 59 West in Weld County, Colorado. The proposed 2,682 acre development is planned from one oil and gas location with a total of 12 horizontal wells. The pad is named the Boom Hog 859-3 pad. This location is within the mineral development area and is located on fee surface in a very rural and remote part of Weld County. As you heard from Mr. Maxey, Weld County is the relevant local government and has approved the Boom Hog pad at 1041 WOGLA 22-0045. There are no proximate local governments. Bison owns leasehold covering more than 45% of the mineral interest in the proposed drilling and spacing unit, and therefore has the right to develop. The spacing unit does contain fee and federal minerals. With respect to spacing, Bison has requested approval of a companion Rule 305 drilling and spacing unit application to establish one approximate 2,682 drilling and spacing unit. The spacing unit, as I mentioned, contains federal minerals, and Bison has submitted federal APDs to the Bureau of Land Management for those unit wells. Those APDs are currently pending. Further, Bison will submit a communization agreement to BLM prior to first production from the initial unit well. Bison maintains that the proposed spacing unit and proposed boundary unit setbacks do satisfy Rule 305B and the Conservation Act, including the protection of correlative rights. I'd like to make a few comments regarding this location specifically. The location is on fee surface, and Bison has a surface use agreement with that surface owner. The pad will develop the drilling and spacing unit with a total of 12 horizontal wells, 6 that will be drilled from the direction of west to the east across sections 2 and 3, and 6 drilled north to south across sections 10 and 15. This pad does not meet any of the Rule 304 B2B criteria, and therefore an alternative location analysis is not required. While not required, Bison did evaluate other potential locations to avoid impacts to public health, safety, and welfare of the environment and wildlife resources. Bison did select the Boom Hog pad as the best of the alternatives, as it has no receptors within 2,000 feet. It's sited well outside of high priority habitat. There are no water resource impacts, and it's sited with the agreement of the surface owner. The Commission's review is therefore pursuant to Rule 301A, and it can and should accept the findings of the Commission staff as set forth in the Director's recommendation for approval of the Boom Hog pad. As you will hear further today, Bison will deploy a suite of best management practices to this proposed location that do satisfy Rule 301A, such that the proposed operations will protect and minimize adverse impacts to public health, safety, welfare, and the environment and wildlife resources. Some highlights of best management practices include a drilling rig that is powered by CNG dual fuel engines with battery backup, completions using Tier 4 engines and a quiet frac fleet, electrified production equipment, three-phase pipeline takeaway, and a tank-light facility design, gravity-fed box proppant delivery system, tank vapor recovery, which is designed to provide 100% control of tank vapors during the operations, continuous emissions monitoring during all phases of operations, including 6 months into production. And with respect to wildlife, as I noted before, this location is sited well outside high priority habitat. And of course, the comment made by Mr. Maxey regarding the burrowing owl survey that Bison is committed to providing under the circumstances that Mr. Maxey described. Notice has been given pursuant to Rule 504A and Rule 303E1, and no petitions or interventions were received. And on November 14th, 2023, the Director issued a Director recommendation which does recommend the Commission approve the Boom Hog OGDP. This application does satisfy the Conservation Act and Commission rules, specifically Rule 604B1 and Rule 301A, with a very thoughtfully selected location that does prioritize avoidance, as well as a suite of BMPs to best protect, minimize, and mitigate adverse impacts to public health, safety, welfare, the environment and wildlife resources. Thus, Bison respectfully requests that the commission adopt the director's recommendation and approve this application. Thank you very much for your time, and I pass the baton to Ms. Gillen, who will begin Bison's presentation.
Good morning, Chairman Robbins and commissioners. It is just still morning. As we convene here, just days after the Thanksgiving holiday, I want to express my gratitude for your time and attention. It's a pleasure to be with you today. I would like to start by introducing myself. My name is Katie Gillen. I am the Director of EHS and Regulatory Affairs here at Bison. I have a master's degree in hydroscience and water resource management from the University of New Mexico, and I have over 10 years of Colorado-specific oil and gas, environmental, and regulatory experience. I'm here to provide you with an overview of our oil and gas development plan for the Boom Hog 8-59-3, and to answer any questions you may have to the best of my ability. Also present with me today is Egan Hogan, Bison's Vice President of Exploration and Geology. Egan holds a Bachelor of Science from UC Santa Barbara in Environmental Science and a Master's degree in Geoscience from Colorado State University, with the vast majority of his experience in the DJ Basin. He is available to answer any subsurface questions you may have. I would like to start by giving you an overview of our company, Bison Oil and Gas 4. Bison operates in the DJ Basin, both in Colorado and Wyoming, and the team has operated in the basin since 2016. Bison 4 is now the 6th largest producer by BOE in the state. We take pride in our Colorado origins and are committed to developing oil and gas in a responsible manner and contributing jobs and growth to the local economy. Our foremost goal is to excel in the DJ, and we have a deep understanding of the technology, operations, environmental, and regulatory requirements essential for producing some of the world's cleanest and responsibly sourced oil and gas here in our state. Our headquarters are here in Denver, and we have a field office in Brinsdale in Weld County. We have grown over the past year to 60 full-time employees. We operate about 100 wells in Colorado, and in 2023, we will have drilled 29 wells and will have completed 24 by the year end. I will begin by giving you an overview of our Boom Hog surface location. The Boom Hog surface location is sited in Section 3, Township 8 North, Range 59 West, and lies within the OGDP's Mineral Lands Development, which includes 2,629 acres in Section 3, 2, 10, and 15. The OGDP contains a single surface location where we will develop one DSU with wells running east and south from the surface location. The Boom Hog is located in a remote area zoned agriculture in unincorporated eastern Weld County, approximately 5.5 miles east of the town of Keota and 8 miles northwest of the town of Raymer. The total disturbed area during construction will consist of 15 acres of new surface disturbance, and the size of the location after interim reclamation will be 10.6 acres. The access road will be 0.2 acres of new surface disturbance. There will be 12 horizontal wells and associated production equipment. Oil, gas, and produced water will all be piped from the location. The access will connect to Weld County Road 115. An overview of our permitting timeline. Bison initiated the permitting process for the Boom Hog OGDP by completing our Weld County pre-application consultation on November 23rd, 2022. ECMC, CDPAG, CPW, and BLM were all invited to our pre-application meeting, and no issues or concerns were stated by any attendees regarding the proposed surface location or development plan. CPW provided consultation comments on the location to Weld County during the permitting process, which Jason Maxey had highlighted for you earlier. CPW staff found no impacts to high priority habitat. They requested Bison perform a migratory bird survey prior to construction if operations were to occur during burrowing owl nesting season. We have agreed to perform the survey. CDPHE was also notified, but they did not request further consultation. We submitted our WOGLA application on June 6, 2023, which was subsequently approved on September 21st, 2023. Bison submitted our OGDP application to ECMC on July 20th, and the application passed completeness on September 21st, and we received the director's recommendation for approval on November 14th. There are no public comments received on either the WOGLA application, the OGDP, or Form 2A. We have submitted our Fed APDs for the 6 federal wells in the project. Those permits are currently pending. View of the mineral lands. The OGDP encompasses both fee and federal minerals. The proposed DSU would establish 2,682 acres from the Niobrara Formation and approve up to 12 wells. Bison utilized a single large DSU for application lands, eliminating the need for multiple individual wellbore spacing units. In sections 3 and 2, Bison will be drilling 5 2-mile lateral federal wells and 1-mile lateral federal well from east to west. In sections 10 and 15, Bison will be drilling 6 2-mile lateral fee wells from north to south. An overview of the surface location. Bison evaluated 2 other possible locations and considered key cultural and environmental features to avoid and mitigate impacts when selecting the Boom Hog 8-59 surface location and access road. The location was selected as it avoids all criteria under Rule 304B2B. None of the following ALA criteria applies to the location, including there are no residential building units, high occupancy building units, schools, or child care facilities within 2,000 feet, all of which are over 1 mile away from the location. The pad is not located within a floodplain, and it is not within 2022 or 2023 high priority habitat. There is also no disproportionately impacted community within 2,000 feet of the location. For these reasons, no ALA is required. Bison believes this is an exceptional location based on the 2 other possible locations evaluated during the WOGLA application process. We have included a map depicting cultural features under Rule 304B2B to highlight the remote nature of the location and minimal impacts on environmental features. RBUs and high occupancy building units, schools, and disproportionately impacted communities are all over a mile away from the location. The nearest high priority habitat since the effective date of the 2023 high priority habitat maps is 4,756 feet away from the location. There are no nearby sensitive water receptors within, and with the closest surface water being 1,630 feet away. Furthermore, this location also provides ideal access to the underlying minerals as well as access to the existing pipeline infrastructure. and has close access to Weld County Road 115, thereby reducing the need to construct more new surface disturbance to build a longer access road. Additionally, the area is surrounded by other oil and gas development. There were 2 alternative locations evaluated as part of the Weld County permitting process. The first alternative location, the blue polygon in section 16 in the bottom left-hand corner of the slide. The positive aspects of this location included it was also outside of a floodplain, outside of high priority habitat. There were also no RBUs, schools, or child care centers within 2,000 feet, no wetlands or riparian areas, no navigable waters. The negative aspects of this location included it would require additional new surface disturbance to build a longer access road to the nearest county road in comparison to the Boom Hog selected location. The location poses significant additional engineering and technical challenges for bison due to the long step out required to access the minerals in section 3 and 2, and may even prohibit full development of those sections. The location, additionally, since then, the location was sold and is operated by another operator that is now producing a horizontal well production facility from the location. Therefore, it is not feasible or safe to develop the Boom Hog wells from this existing operated location. The second alternative location evaluated, the pink polygon located in section 4. The positive aspects of this location included being outside of a floodplain, outside of high priority habitat. There were no RBUs, schools, or child care centers within 2,000 feet. There was, however, a wetlands mapped wetlands to the east of the location. Oh, sorry, to the east of the location. Additionally, the landowner was not supportive and would not grant an SUA for this location. Therefore, bison selected the proposed Boom Hog surface location. Just to review our siting rationale once again, we believe the Boom Hog surface location and access road are exceptional locations as they avoid all criteria under Rule 304B2B. In addition to the remote nature of the location, bison further minimizes impacts by developing in close proximity to the underlying minerals and existing infrastructure. Bison conducted an initial biological survey where we found no sensitive species habitat. The selected location also minimizes drainage issues and has no substantive topographical challenges. And bison has support of the surface owner and a secured SUA. Furthermore, during the Weld County pre-application process, there were no issues of concern expressed by any attendees or those notified to participate. Neither Bison, Weld County, CPW, or ECMC staff had any issues of concern with respect to public health, safety, welfare, and the environment. The proposed access point for ingress to the well pad is from Highway 14 north to Weld County Road 115, which is the nearest connector road. Travel distribution is expected to be 50% of traffic coming from the east on Highway 14 and 50% of traffic coming from the west on Highway 14. Our siting rationale for the access road: it avoids towns, schools, facilities, future school facilities, and child care centers. Bison has, in addition to selecting the access road to avoid these features, also implemented traffic reduction measures. The location, as stated earlier, will be connected to oil, gas, and produced water pipeline takeaway, which significantly reduces truck traffic associated with hauling. The location is also equipped with automation to allow for 24-hour remote monitoring. This monitoring also helps reduce daily truck traffic to and from the location because Bison personnel can turn on wells and equipment, measure tank levels, and verify pressures and temperatures through this system. Our operational timeline. Bison, pending all permit approval, would plan to begin pad construction in early January 2024 and start drilling operations early February 2024. And we would intend to finish drilling operations in March of 2024. At which point we would also begin completions in early May and finalize completions in June, with the date of first production occurring in mid-July. Bison plans to fully develop the DSU in a single occupation. Contingent on permit approvals, Bison plans to drill wells before May to avoid impacts to ozone season. An overview of our BMPs to avoid, minimize, and mitigate impacts during drilling and completions. Bison has included best-in-class BMPs to avoid and minimize impacts during drilling and completions. We plan to complete drilling. We plan to make every best effort to complete drilling prior to ozone season, subject to timely permit approvals. Our drill rig is powered by CNG fuel engines with battery assist. This reduces fuel usage, thereby reducing associated drilling emissions. Group 2 drilling mud, which has a reduced emissions profile, shortens drilling time on location, which further minimizes drilling emissions. We will utilize a closed loop pitless system for drilling, Tier 4 engines for completion operations, quiet frac fleet for reducing noise. Fresh water delivery via lay flat lines will be stored on site in an MLVT, thereby reducing truck traffic for freshwater hauling. We will have an OSHA approved gravity fed proppant delivery system that reduces sand dust during fracking operations via direct sand delivery into the blender and sand hopper. During the production phase, Bison will also implement BMPs to avoid, minimize, and mitigate impacts. Oh, apologies. The facility will be equipped with oil, gas, and produced water pipelines, eliminating more than 35,000 water hauling truck trips and more than 61,000 oil truck trips. If the gas pipeline goes down, Bison will shut in and there will be no flaring. Pneumatic controllers will be operated by instrument air, thereby eliminating those associated emissions. The storage tanks will be equipped with tank vapor recovery design, which provides 100% control of tank vapors during operations. Continuous emissions monitoring during completions and first 6 months of production. The pad will be connected to utility line power to operate the production facility and electrify. Bison will implement our robust inspection and preventative maintenance program, including daily AVOs and OGI inspections per Reg 7. Wildlife overview. This location and access road are wholly outside of high priority habitat, and the nearest 2023 HBH is 4,756 feet northwest from the mule deer winter concentration area. As part of the Weld County permitting process, CPW was consulted. Again, CPW found no impacts to HPH. They did request a migratory bird survey prior to construction if construction was to occur during nesting season. Bison has committed to conduct the pre-construction nesting migratory bird survey. Additionally, as referenced earlier, during location selection, Bison's initial biological survey found no sensitive species habitat. BMPs include quiet frac fleet to reduce noise. There will be no fencing to prevent blocking migration. We will develop the DSU in a single occupant. In conclusion, some highlights from the director's recommendation and ECMC staff. There were no opposing public comments received on the OGDP. We have received our approved WOGA application. The proposed boom hog location does not trigger ALA. Impacts to public health, safety, and welfare will be largely avoided, minimized, and/or mitigated by the successful implementation of our site-specific BMPs. And based on the siting of the surface location, potential impacts to water resources are not anticipated, and CPW did not identify any impacts to wildlife habitat. Director has determined that this OGDP complies with all the applicable rules and has recommended approval. I would like to thank you all for your time and attention, and I can now take any questions you may have regarding our application.
Thank you very much, Ms. Gillian and Mr. Prashala, for the presentation. The panel is open for questions from commissioners. Well, I told you did a good job. It doesn't seem we have too many questions here today. Do you have anything further to wrap up, Mr. Prashala?
I would just summarize that under the commission standards under Rule 301A, obviously the goal is to avoid and then minimize and mitigate impacts. And I think what you've heard today is that the site selection of the boom hog pad definitely avoids impacts to all receptors under Rule 304. B2B. It also avoids any impacts to high priority habitat. And then as you have a list of the best management practices that were identified by Ms. Gillen do adequately minimize and mitigate impacts in satisfaction of Rule 301A, those impacts that can't be avoided entirely. So with that being said, Bison requests that the commission approve this OGDP application.
Very good. Does anyone desire to, if I could have the witnesses mute. Does anybody desire to initiate deliberations on this OGDP? Commissioner Messner?
Thank you, Mr. Chair. I'll go ahead and make a motion to approve the OGDP as presented.
Have a motion. Do we have a second?
Second.
Motion and a second. Is there further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Prashala. Thank you, Ms. Gillian. And thanks to staff for doing a good job of evaluating this approved oil and gas development plan. Okay, commissioners, we've got one more matter. It's not long as far as I can tell. Are you comfortable plowing through it and getting through our agenda? I know a couple of us have some other matters this afternoon. Mr. Prashala, would you be able and willing to present this last OGDP? I think it's yours.
It is mine, and I am happy to push on forward. I see Mr. Condrat has been elevated, and I'm looking for Ms. Gross. When she is elevated, we would be able to start. If you just give me one moment, I need to put something up here on my end.
Ms. Mercer, do you want to swear in the witnesses?
Yes, thank you, Mr. Chair. So panelists, I'll just go one at a time. Oh. Okay, I'll ask you each to raise your right hand, state your name, that you swear to tell the truth. Ms. Gross?
My name is Andrea Gross, and I swear to tell the truth.
Thank you. Mr. Condrat?
My name is Peter Condrat, and I swear to tell the truth.
Thank you.
All right, Mr. Marshall, the floor is yours.
Great. Well, I think we are now afternoon time. Good afternoon, Mr. Chair and Commissioners. As you know, my name is Joe Kershaw with Wellborn, Sullivan, McIntooley, and I'm here on behalf of the applicant B&L Enterprise. With me today are Peter Condrat, Chief Operating Officer of B&L, and Andrea Gross, who's the project lead for upstream petroleum management, who worked on all the permitting efforts for this OGDP. B&L has one application before you today, and it's similar to previous applications that have been presented in the past regarding helium development in Los Animas County, Colorado. B&L's Bowling Daniel OGDP covers approximately 510 acres in Los Animas County, and that's in portions of sections 4, 8, and 9, Township 29 South, Range 60 West. The application does request the Commission to approve 4 oil and gas locations, and the names of those are the Bowling 4 Northwest Southeast 2960 pad, the Bowling 4 Southeast Southwest 2960 pad, the Bowling 9 Northwest 2960 pad, and the Daniel 8 Southwest Northeast 2960 pad. B&L proposes to drill 1 vertical well on each of these locations to explore and produce helium gas from the Lions Formation. B&L's leasehold is in fee ownership that grants B&L the right to produce helium gas, and the fee lessors are also the surface owners for each of these locations. The lands are not subject to any commission spacing orders and therefore are subject to Rule 401. B&L is proposing to develop the application lands on a leasehold basis subject to Rule 401B. Specifically, that is, the Lions Formation is less than 2,500 feet in depth. The wells will be located more than 200 feet from the lease lines, and there are no other existing or permitted wells in the Lions Formation within 300 feet of the proposed wells. Therefore, no spacing is required, and spacing has not been applied for. These locations are proposed on rural rangeland on fee surface, and B&L has worked cooperatively with the surface owners and has surface use agreements with them that memorialize the parties' agreement as to these locations for the well sites and access roads. The locations do not meet any criteria under Rule 304B2B. Therefore, an alternative location analysis was not required and was not conducted. Thus, the Commission's review is pursuant to Rule 301A, and we request that the Commission accept the findings of staff as set forth in the Director's recommendation for approval of the application. As you will hear today, the locations are on a remote part of rural, privately owned rangeland. There are no receptors within 2,000 feet of these locations. The locations are outside high priority habitat. There are no water resources in the vicinity of the locations. That B&L's helium operations are very low impact, and B&L has agreed to surface use agreements with the surface owners that are governing the operations on the land. Based on these considerations, the Commission's applicable operating rules and regulations, B&L submits that this siting of these locations does avoid adverse impacts, and that the best management practices for these operations will protect, minimize, and mitigate adverse impacts to public health, safety, and welfare in the environment. Los Animas County is the relevant local government. It does not regulate siting of oil and gas locations. B&L has consulted with the county regarding these locations, and the county has not objected to any of these sightings. The county does require building permits, and those permits are pending approval of this OGDP application. Notice was properly given pursuant to Rule 504A and 303E1, and no petitions or interventions have been received. And on October 26, 2023, the director issued her director recommendation recommending approval of this application. And with that, B&L does request that the Commission approve this oil and gas development plan application and adopt the director's recommendation. And with that, I would turn it over to Mr. Condret and Ms. Gross, who will provide you with a presentation on this development plan and the locations and answer any commission questions. Thank you.
Thank you, Joe. Hello, Mr. Chair Robbins and commissioners. We sure appreciate the opportunity to present our OGDP. We have a short slideshow. These are similar slides you've seen before. This is just the introductory slide. Andrew, go ahead to the next slide. Here's our disclaimer. Next slide's our agenda. We'll briefly go over our proposed locations. We'll go over the site selection process and talk about our impact avoidance minimization. So we've got the Bowling Daniel OGDP. This map shows the 4 locations, 1 vertical helium well per location. None of these locations are high priority habitat. As Joe indicated, this is a rural ranch land area. None of our proposed locations are applicable to Route 304B. There are no residential building units or other cultural features that are within 2,000 feet. The helium gas will be piped to a central gathering facility for sales transport. Next slide, please. You know, I've been paying attention all day and sent to the meetings. You know, B&L is more than happy to meet with the director and go over its development plan and give a good idea about what our potential plan looks like. But I do let you know that we don't think CAP is appropriate for our area. We have a very wildcat nature. This is an area that has few historic wells. We're still learning about our reservoir and structure out there. We're still in the process of leasing and getting agreements for more wells in the area. But again, we don't have those next step wells really finalized. And so we present these wells as our current OGDP. We've gone through the process with surface owner relationships. We've had consultation and contact with all the owners in the area. Remind you, this is fee surface and fee minerals. And again, this is an area that does not have any major development. It's a rural rangeland area. We've also avoided wildlife, wetlands, and surface water features. Next slide, please. This just kind of goes over our helium wells. You know, the helium wells that we're doing is a very low impact nature of drilling. You know, we've got a small rig, water well rig. We've got a small footprint. We've got no drilling mud. We've got no fracking. We use a rig liner after the surface location is built and put everything on top of that rig liner. Potentially there's any kind of spills associated with the equipment. This is an area that has no hydrocarbons, never has, don't anticipate any. You know, we follow all the best management practices, manage stormwater runoff. It's a flat area. Next slide, please. And again, we've got very concise packages and what our development looks like ultimately with the helium plant and the wells. Next slide, please. Just, you know, if there's any questions, we could certainly talk about the helium, what it's used for, or what it means to production out there. But again, this reservoir, the Lions Reservoir, is our helium target. It's a sandstone, relatively shallow reservoir. There are no hydrocarbons. There's no drilling mud to do these. It's a really low footprint, small footprint, and low impact to the environment. Next slide, please. Kind of covered all these things. I guess I'll wait for more questions. Next slide, Andrea. And then I'll let Andrea take over. Andrea is our third-party consultant for our group.
Good afternoon, commissioners. As I stated earlier, my name is Andrea Gross. I'm the president of Upstream Petroleum Management, and I'm acting as BNL's permit agent. I prepared and submitted the OGDP, including the 2A, 2B, and 2C. I'd like to briefly go over some site-specific about all 4 locations. However, all 4 locations are very similar in their footprint. The Bowling 04 Northwest Southeast 2960, as you can see on the maps, very rural. It didn't trigger an ALA. It'll have approximately 1.4 acres of disturbance, but it'll be reduced down to only 0.2 acres after interim reclamation. Okay. The next one is the Bowling 04 Southeast Southwest 2960. Very similar to the previous one, although this one will only require 1.2 acres during drilling, and then it'll be reduced again down to 0.2 acres. This was even further from the, there is like a residential building unit. All of them are greater than 2,000 feet to any of these locations in the OGDP. The third one is the Bowling 09 Northwest Northwest. All three of these locations are on the same surface owner, and BNL has a great relationship with that surface owner. Again, it is only 1.2 acres of disturbance will be reduced down to 0.2 acres. This is also greater than 2,000 feet from any receptor and did not trigger any ALA criteria. The last one is the Daniel 08 Southwest Northeast 2960. This is in a different surface owner. However, BNL has a very great relationship with this surface owner in the area as well. Very similar, only 1.2 acres of disturbance for drilling, and then it'll be reduced down to 0.2 acres after interim reclamation. This location also did not trigger any ALA criteria. And then these are just some bullet points on how BNL, what they use to avoid, minimize, and mitigate impacts. One of which is their site selection. They always try to choose sites that will avoid triggering any of the 304B2B criteria. And they were very successful in that one for this OGDP. They try to avoid all high priority habitats, floodplains, wetlands, and any other sensitive water resources in the area. Helium development does not produce any hydrocarbon emissions. They would be using a rig that is air drilling, which avoids the use of drilling mud and related emissions with mud. These wells do not require hydraulic fracturing. They're very small, like I stated, 1.2 to 1.4, and then reduced down to 0.2 acres after interim reclamation. And in this area, the field production will be piped to a central gathering facility, which minimizes the truck traffic in the area. And that concludes our presentation, and we are available for comments and questions.
Great. Thank you very much for the presentation. Commissioners, we have one last panel that is open for questions. Commissioner Bessner.
Thank you, Mr. Chair. Not a lot of comments or questions on the particular application. I am curious though how you're taking into consideration surface disturbance associated with access road in your total surface disturbance acreage that you're providing.
I can take that question. Correct. The disturbance that I mentioned was only for the oil and gas location itself. There is some existing access roads in that area that will need some upgrading. However, the surface owners in the area are very excited about the prospect of having some road improvements. There are some 2 tracks that, for example, the Bowlings, there is some existing 2 tracks. BNL has tried to use existing 2-track roads that will be upgraded to maintain kind of the same footprint that is in there right now. This area with the Voyager, they're calling it the Voyager location, it does have a pretty significant existing county road that all of the roads will be constructed off of, and they're working with the Los Animas County Road and Bridge.
And just to give me an idea, I mean, how long are the access roads that you're contemplating to these sites?
Some of them are
and I'm not including the county roads and stuff. I'm
right. Yeah, there is one, and I can pull it up down to the furthest one, which I think is the Daniels, or actually the Bowling 09. I think it may be a mile of upgrading a road.
Okay.
Yes, Andrea pointed out, just sorry to interrupt you, Commissioner. These are along existing two tracks. There's minimal new access. Everything's along existing access or two track roads. There's a couple 100 feet instances we have to do to the pad. But other than that, it's existing areas.
But you're upgrading them from two track to hardened gravel surfaces, is that right?
Correct.
Correct. We're upgrading to the point where they're going to be accessible by a rig and then a well tender. But we're trying to minimize the impact where we're not running like a access road that's going to be used by many people, just a few people to access these wells.
Okay.
I was incorrect. I pulled up the plats for the Bowling Daniels, which is the furthest south. It's an additional 1.8 acres of road work.
Okay. Thank you for that. That was the question I had. I'll have some thoughts during deliberation about considerations or benefits at looking at things a little more landscape level for helium operations in this particular area.
Other questions for the panel? Seeing no further questions, does someone desire to initiate deliberations and or make a motion? Commissioner Messner?
No one wants to talk today but me. But so I mean, this is an approvable application from where I'm at, and I'm happy to make a motion for approval. I will, however, make a comment that I do think that there needs to be some considerations in this area as we're looking at more and more applications for single well operations that include longer access roads. And while the well pads themselves, at least the ones that I'm currently seeing, don't seem to be contemplated inside of high priority habitat areas, it does appear that they are adjacent to high priority habitat areas with access roads potentially going through or being even closer to high priority habitat areas, and the habitat fragmentation by significant single well pads and access roads associated with those have the potential, in my mind, to be relatively significant and are worth having a more comprehensive look at the potential impacts and opportunities for avoidance, minimization, and mitigation in those particular instances. And so I would love to see the director, like we provided guidance to earlier today for WaveTech, to be able to meet with this operator to look at potential opportunities for looking at things a little more landscape level rather than OGDP by OGDP, where it's more difficult to be able to evaluate some of these potential impacts. But I do make a motion to approve the application.
All right, we have a motion and we have some direction. Anyone else with thoughts? Do we have a second?
Second.
Motion and a second. Is there further deliberations? All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries.
Thank you.
Prashad, thank you, Mr. Condrat and Ms. Gross. Appreciate the presentation. Your project has been approved.
Thank you, commissioners.
With that, commissioners, I believe we've concluded our business with a hearty morning's worth of work here. Would look for a motion to adjourn.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned.